his remorse. Oceans you fill for yourself alone. Forest Samson that now dethroned. So pity your river, not a drop for him. Your high ground's a shadowy wasteland. Samson, not back with your selfish walls. No room for the tears, only you.
Hey guys, it's Mo, and we are getting into the Sarah Boone shenanigans that happened yesterday. Welcome, Publicly Buzzed, Debbie Webb, JW, good to see you, and Christine. Hope you all are doing well. I'm going to be real with you. This is a public service announcement. Mo just experienced her first hot flash of and I don't know how humanity survived that last night. So we are going to go complete pettiness. We are going full petty parade here. I don't have a moral high horse. I have a moral or mini hornicorn. That is what my littlest calls unicorns. So, yes, I know that my moral high horse should not be that high, but today I give I'm in full F deficit. So, at least for Sarah. So, I figured I'd give that public service announcement that I wasn't going to be kind and considerate. And I have the Sailor Moon wand of justice if we need to excommunicate Sarah from any more churches. She's already been excommunicated from the woman church. She is now a female. But if we need to downgrade that more, we are certainly able to. With Mr. Mo's like, if you do not use all this stuff that you continue to buy of Sailor Moon, you're not allowed to buy more. So I'm like, oh, this will be a parade of Sailor Moon merchandise if I'm allowed to buy more. Anyhoozle, let's hope that Judge Eyebrows of Justice, the illegitimate love child of DeSantis and Ted Cruz, holds Sarah Boone and, Owens feet to the fire. We can only hope. Or we need to start paying for this man's bourbon account because he's going to need it. Just going to actually get us to where people are. The youngest, most feral has decided to stay in the courtroom, in the room. And he's like, of course I can be quiet and not bother you. We are not even 3 minutes in. Are you on? Okay, you guys, my first petty comment of the moment of the hearing is, does the hairstylist and makeup person that is unfortunately going to have to work on Sarah Boone, do they have an actual working magic wand? Because they're supposed to make her approachable and human looking for the jury. Well, unless she is the fairy godmother of, the Florida Keys. I don't know how that's happening, but God bless that makeup artist. May the peace of all of us in humanity be upon you. Because that's a job. That's a job not even Samson with his hair could deal with. And yes, this is super petty, Justeel. I gave y'all a warning. This is all petty all the time. Oh, for the love of Cheetos, why don't you start when they start talking? All right. Nope, still silent. Oh, there's Eyebrows of Justice. Thank you, Jesus.
Gork, I'm ready when you are.
Okay, y'all, tell me I'm wrong. Does this judge not look like the illegitimate love child? There was no woman involved of Governor DeSantis and Ted Cruz, they had a child somewhere, or they were possibly all brothers. I'm just saying. 1 second. Griffin, out. Okay, so my youngest, most feral, did not want to spend time with me because he loved me. No, he wants to take my new walker and ride it around. I am loved. All right. Come on, brows of justice.
David Ketchstraw on behalf of the state.
William J. for the state.
James Owens for Sarah Boone.
Okay, I have it boosted as loud as I can.
Good afternoon, everyone. Ms. Boone, good afternoon. If you could please state your full name and date of birth for the record for me.
Sarah Boone, 10-10-7-7.
Okay, we're here on several different matters,
Okay, well,
including.
I'd like to lodge a complaint with the universe. First of all, my youngest daughter, the child who so graciously, if I were to have a child that would have been Mo on Spinal Tap 11 from birth, it would definitely be my youngest daughter. And her birthday is, well, 10/11. And I refuse for her to share a birth month with this woman. So we're excommunicating Sarah from the October birthdays by the power vested in me by me and for my sanity. All right, I've got the audio. Look, maybe I'll see if Veilhammer can look at this. I know he's really, really busy, but maybe we can get him to fix the audio a little bit. At a future point.
Including a motion to suppress, specifically the motion to suppress defendant statements at OCSO filed September 24, 2024. The amended motion to suppress defendant statements at OCSO filed September 30, 2024. And then just what was filed this afternoon at 2:35 p.m. Defendant's second amended motion to suppress defendant statements at
Hey, Owens, it's called an actual timeline. Owens, it's called a deadline. Have you ever heard of one of these? I think I'm going to need this for this particular hearing because I have a feeling I'll be able to understand Sarah better with a brain slug on. So let's get this going. I am, in fact, an adult. Some days, let's be honest, I fake it most days.
OCSO. State, have you had the opportunity to review the second amended motion? Are you ready to proceed on that today? Okay. Are there any housekeeping matters we need to address from the state side of the ledger?
Not on that motion.
Okay. Any housekeeping matters on your side of the ledger, sir, with regard to those motions to suppress?
No, sir, Judge. I believe we've got two detectives outside to testify, and we've also got the custodian of records from the Orange County Sheriff's Department relating to
The hell you do. You were given a cease and desist order and to stay away from, 20 paces of the Florida government. But okay.
card and the policy.
Is that a valid argument that you're still embarking on this afternoon based on what's in your second amended motion?
Yes.
Okay.
Okay.
So
Mr. Owens, this is a warning. It's like when parents ask you, is that really the answer you're going to go with? Or when your wife says, fine, everything is fine and it's okay. These are danger signs, but he's just going to plow right on ahead if I know Mr. Owens.
So the sufficiency of the Miranda waiver is still at play?
Yeah.
Okay. All right. Thank you, sir. With regard to the other motions that were set for today, and I have reviewed the state's motion to strike, and I have reviewed all of the case law authorities that y'all have provided to me as well.
Yes, the
With
state
regard to the
had
defendant's
authorities.
motion for hair, cosmetics, civilian and clothing without restraints for trial, Mr. J, do you have any position with regard to the restraints at trial portion of that motion.
I do too.
A lot of the case has already been settled on that issue.
Okay, all right, we'll entertain argument when we get there. And I've also reviewed the state's request for protective order filed September 30, which is also set to be heard this afternoon. With that, we'll begin with the motions to suppress. State, you can call your first witness.
Judge, I'm not objecting to the authenticity of whatever it is he subpoenaed. I've been getting some of the documents, Orange County Sheriff's Office General Order 711. I don't see any need to belabor the custodian of records sitting around. Was there something else? You're actually a Miranda card? Or
Yeah, if you.
I am sorry, Swifty. I don't know.
In the very back. Look in the very back.
Okay.
You see the Miranda card? The last page is next to the last page.
Yeah, there's no need to keep the custodian of records around for authenticity. We still have our objections.
Okay, all right. Can the custodian then be released by virtue of the state's stipulation as to that, those records?
Yes, can I go tell her she can?
Yes.
The custodian of records was like, why was I here to begin with? Custodian of records, I hope you at least got like a good Olive Garden, lunch for your troubles.
I also have reviewed the 2 hour and 6 minute investigation that's pertinent to the motion to suppress. The court has reviewed the entire video. With that, State, you may proceed.
State would ask the court or the clerk to mark A for identification as a DVD, emergency copy, body worn camera.
Lapel pens are a thing. I do have one. I got it off of eBay though, so I don't think it was actually correctly working, but I do intend to get one so I can do more standing up chalkboard videos. What do the
I
courts
have
not
reviewed
know
all
about
of those
this?
in advance of today's hearing. Any objections?
No objection?
What was pre-marked as States A will be received into evidence without objection as States 1.
Ooh, Detective Candy. And she looks like Farrah Fawcett. I'm here for it.
Good afternoon, ma'am. Could you state your full name for the record and spell it for us?
Yes, it's Chelsea Castle, Chelsey. Last name is Koepsell.
Thank you. Counselor, you may in court.
Thank you. Where do you work, ma'am?
The Orange County Sheriff's Office.
And what do you do for Sheriff Mina?
I am a homicide.
How long have you been a homicide detective?
Over 6 years.
What's your total experience with the Orange County Sheriff's Office in terms of years?
I am going on 12 years.
Any prior law enforcement experience prior to joining the Sheriff's Office? And in the homicide unit, how is it that you get notified?
Jung,
that
thank
shall
you
be
for
the lead
showing up.
investigator on a case.
So
I was just looking at the good hair.
for this case specifically, my team was on call that week for homicides. And so deputies on the scene to notify the call center, to notify the on-call homicide.
All right, and is it fair to say that you guys have 3 teams of 4?
Yes.
And each of the third weeks you will be on call?
Yes.
Yeah, but she looks so good. She looks so good with the resting bee face. I mean, I'm just over here wishing my hair would look like that when I don't wear a wig. It's growing, but it'll get there. And I have wigs.
And then through some other random distribution, it's determined who of the 4 will be the lead?
Correct.
And it was your turn to investigate the death of Jorge Torres?
Yes.
And you were notified of this on February 24th of 2020 in the afternoon?
Yes.
About what time were you notified?
to look at the CAD sheet to recall directly, but I would assume within 30 minutes to an hour of deputies being on scene.
All right, and do you go to the scene first, or do you do anything else?
Samsonite, I think.
For this
Or
particular
stay
incident,
locked.
I got my partner, Detective Sarah Boone, and we headed out to the scene.
All right, and when you got to the scene, what did you do?
I met with the deputies there, and they kind of just briefed me on what was going on and what they responded to.
Did you do a walkthrough of the scene?
I did, yes.
And then was a search warrant drafted for the residence and later executed?
Correct.
Did you have any contact with somebody identified to you as Sarah Boone on the scene?
Yes,
Do you see Sarah Boone in courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's over here on my left, and she's wearing blue.
May the record reflect she's identified the defendant.
Record will so reflect.
When did you first have
Officer, objection, chance to be petty. I'd have said, it's the heifer over there in the handcuffs. She has terrible hair. She's going to be requesting a wig that looks like my hair next week. Publicly buzzed, you are me. You are me. We would be unable in the presence of Sarah Boone to be professional. No, Jung, this was actually the detective that did the first kind of in the car interview with Sarah that was only audio. And then she was the female officer that actually interrogated her, or as Sarah would say, tricked her and, forced Sarah, the Mensa member, to confess.
have contact with her?
If I'm not mistaken, she was outside of the apartment when I got there. So once I spoke with deputies, I then went and introduced myself to her.
Good
All right,
morning.
and did you ask her
lady.
any questions at this time as you guys are standing outside of the residence?
Not like detailed questions about like what happened, because I already was told by deputies what she had told them. So it's more
This
just
is
to, like,
Detective
introduce myself
Candy,
and to let her
yes.
know, we're doing a search warrant and the procedures of how we do things.
And when you respond to a scene, do you respond in plain clothes?
I do, yeah, like business professional.
Like what you're wearing?
Yes.
And when you make contact with her outside,
Did you notice that little smile like you noticed my outfit? Look, men, you think we women are complicated, but we're not. Just tell us we're pretty, throw chocolate at us when we're angry, and never, never, never tell us while we are, having a hot flash that, wow, you look sweaty and gross. I can't imagine what menopause is going to be like with that. This is more just for Mr. Mo. God rendered me unable to move from the couch, so that was his only saving grace.
side of her residence for this first contact, were you alone or was your partner Scott Lowen with you?
I believe Scott was with me.
And was he also similarly dressed in business casual?
Yes.
All right. And so how long was this initial interaction with Ms. Boone?
Not long. Maybe a couple minutes to a few minutes.
Okay. And this was out on the sidewalk in front of her home?
Yes, if I'm not mistaken, she was at a neighbor's residence, like sitting out on their like front porch area.
Do you recall what you asked her in this initial contact?
Do I recall what?
You asked her?
No.
Okay.
I would recall what I asked her because it would be, why the hell did you put him in a suitcase? And that's not how hide and seek works, ma'am. I'm going to need you to think of a better alibi. I do love that. I will find a red shiny shirt at Goodwill. I'm putting it in the repertoire for this trial. I will find one.
So it was just a couple of minutes that you were there with her?
Yeah.
Okay. And then what do you do after your first contact with her?
So once I did my walkthrough, we decided to go with a search warrant for the scene. So that was written by somebody else. And then once that was executed, we went in there further with CSIs. And then we talked to Brian Boone, which was the ex-husband. And then I believe we then sat there and
Awesome possum.
to our unmarked
Twinsies.
conversation.
Was that conversation in the unmarked vehicle recorded?
Yes, audio recorded.
And can you describe this unmarked vehicle for the court?
At the time I was in a unmarked Pathfinder, so it was like gray in color, didn't look like it didn't say like law enforcement or police or anything on the exterior. And there were lights like inside.
Ma'am, are you saying you were driving a Decepticon? I feel like that's entrapment. I'm with Sarah Boone now. She was in a Decepticon to, enslave and I'm just kidding. It's an odd day. I'm wearing a brain slug, people.
Where did everybody sit in this Pathfinder?
I sat in the driver's seat, Sarah sat in the front passenger seat, and Scott Lohan sat in the back seat.
Did you have any
One would
conversation
hope.
with her about the facts of the case or your investigation that wasn't recorded inside the car?
No.
And that was all recorded and turned over to the state attorney's office?
Yes.
And you announced the date and time of the start of this interview on that recording, did you not? Okay. Is it fair to say that it had been about 3 or 4 hours since the initial call out for 911?
Yeah, I would say, yeah, because I believe we started interviewing her right before 5 p.m.
And is there any particular reason for executing the search warrant and speaking to another witness or witnesses prior to interviewing Miss Boone?
Just based off the situation and what was happening.
At least we have closed
Is it in
captions.
any way unusual to gather evidence before talking to the last person to see a decedent alive? At some point during this day, which was February 24th of 2020, was her cellular phone device collected?
It was
And when was that?
that same day.
I mean, when time-wise in relation to talking to her?
Oh, well, I noticed the phone was in the kitchen area, but I didn't touch anything until CSI's documented everything, photographs. So I don't think I really touched it until after I had talked to her about going through it.
All right. And ultimately, was she placed under arrest on February 24th, 2020?
No.
After she got out of her car, was she free to remain on the scene or free to leave?
Not go back in her house. But
Prior to that, had she been detained and requested not to leave the scene?
one more time.
Prior to your interview with her in the car, had she been asked or ordered to stay on the scene?
Not by me.
February 25th, was there a second interview conducted with you and Detective Lowen with Miss Boone?
Yes.
Prior to this interview, had her phone been extracted by any member of the digital forensics team at the sheriff's office?
Yes.
All right, and had you reviewed some of the evidence on there? You had requested that Miss Boone come down to the sheriff's office rather than you returning to the scene.
Yes.
Can you explain that?
It's more of a controlled setting for law enforcement. We were able to audio and video record at the sheriff's office, and she had mentioned that she might not be staying at her apartment, and so I didn't want to go to the ex-husband's residence where her potential child was. So I just felt it was a more controlled setting.
I will say on a completely serious note, I think that this is something that would occur to officers that are parents. Regardless of what Sarah thinks, and if Sarah could pull her head out of her behind for 5 seconds, Sarah claimed that her son, being tormented or traumatized by seeing her arrested or seeing her picked up by police officers, they chose to have her come in. In fact, that was, as some other media correspondents like to say, top of mind. So for Sarah to come out and say, you are all sorts of mean and horrible and cruel and coerced me, they actually had her come in because they didn't want to put her son through anything else with with his crazy A mom.
Setting at the sheriff's office.
All right. And when Miss Boone arrives at the sheriff's office, who goes down to greet her and where?
It was not me. But she would have gone in through, we have two entryways. So either on the record side or on the opposite side. And she would have had to go up to a window and request that she was there to meet with me. They would call me. I would tell them yes, sign her in. And then if I'm not mistaken, I believe Scott, Detective Lowen went down and got her.
All right, so you're describing two separate entrances that members of the public can come and go through,
Yes.
as opposed to separate entrances that might be in the back of your building where people are not free to come in and out of without a swipe card.
Yeah. The public doesn't have access.
All right. Now, in relationship to those two entrances, which I assume are on the first floor of the building, is that a safe assumption?
Yes.
Where are the CID or
I
the
know, right?
investigation division's interview rooms?
They are located upstairs.
All right. And is she allowed to just walk up to the second floor interview room, or does she have to be with an employee of the sheriff's office?
She would have to be with an employee of the sheriff's office.
And your testimony is it wasn't you?
I don't believe so, no.
Now tell us about these interview rooms.
We have 4 interview rooms that are audio and video recorded.
Okay. And they have, you said they're video recorded. Was the interview with Ms. Boone video recorded by the sheriff's office equipment?
Yes.
Was there any conversation about the case or the investigation with her that did not occur inside that room with the recording going?
No.
Okay. I don't have other questions of this witness.
Thank you. Any cross-examination?
Oh, dear God. Thank God I have my brain slug on, so this won't hurt as much.
Detective, I'm James Owens. I met you outside just a few minutes ago, and you know I represent.
Oh my God, that's her bless your heart. That is you lick some windows. You might be on a shorter bus than I was growing up. Kind of, that is a bless your heart smile. She does resting bee face and a bless your heart smile. I'm in love. I'm telling Mr. Moe.
Represent Sarah Boone. Detective, have you had a chance to review any paperwork related to this case prior to this hearing?
I have looked at my investigative report, and I have looked at some policies, but they were from current.
Have you had a chance to view Deputy Kayla Rodriguez's body cam video prior to today?
I've seen it. I have not seen it recently.
Have you had a chance to review and listen to the audio interrogation that was in the unmarked vehicle that you did of Sarah Boone on the day in question?
Yes, I have reviewed that.
And have you had a chance to review the approximate 2-hour interrogation video at the Orange County Sheriff's Department?
Yes.
Would it be fair to say that prior to you asking Sarah Boone to enter this unmarked vehicle for this interrogation with Detective Lowen, that you did a preliminary investigation as to whether or not this was potentially a homicide?
Yes.
And you would have viewed the scene inside the apartment?
Yes.
And you would have spoken to Deputy Rod.
Owens, I think her first clue was we found a man inside an effing suitcase. I mean, I don't think she has to be Nancy Drew, Nancy Grace, and the Hardy Boys to maybe think there was something a little sus about the whole situation. But, I mean, she is also a detective, so.
Rodriguez about what she knew about the situation?
Yes.
And you would speak to Deputy Rodriguez about what Sarah Boone had said had happened?
Correct.
And did you talk to any other people there about the situation prior to speaking with Sarah Boone about the facts in this case?
Just Brian Boone.
Okay. And was that conversation recorded with Brian Boone?
Yes.
And would that have been in your squad car?
Potentially. I didn't listen to that interview. I don't
Okay.
know if we interviewed him outside or in my car.
Was he Mirandized?
No.
Okay. So although he was at the scene when y'all showed up,
Are they trying to pin it on Brian now? Are you Brian, look at me, sweetie. Now, I know you probably can't leave the state of Florida till this trial is done and over with, but when you do, change your name, grow a fake mustache, or buy a fake mustache, grow a mustache, go to Guam if it doesn't tip over. That will never not be funny. But run and never answer any sus numbers. Do not pick up any mail. I'm afraid you're going to have to go full Amish. Which is funny because there's no jury for him to impress during this. Is he practicing his tactic for next week? Oh, good Lord. I hope not, because I don't know that there's enough booze for me to, mix with Diet Sprite for this one. Let's get back to it, though. What a dingus.
he was not considered a suspect or person of interest?
No.
At some point, did you determine that Sarah Boone was a suspect or person of interest?
Congress.
At some point,
Am I right?
yes.
Tell us when that happened.
The next day.
Okay, so at the time of this event, your initial appearance there at the scene, which I
No
understand
idea.
you must have stayed 4 or 5 hours?
Probably.
Okay. At that point, at no time did y'all consider Sarah Boone a suspect?
Well, it's difficult the way you're asking, but she was the only one there. She's claiming that no one else was there. So what I was being told would mean that she was the only person of interest in that situation. But due to not having the autopsy results, we just interviewed her initially, got her initial statement, and then
Wait, you mean these officers could have just dragged her in since she was really the only one in the house, when Jorge passed, but instead they waited for corroborating evidence and circumstantial and electronic evidence to maybe point this not being a tragic accident? Sir, you are destroying your point right here, and I don't think you understand that them not taking her immediately actually plays against you, because it shows that they actually did conduct a thorough investigation. Interesting. This man was a lawyer before, right? Like, I've heard that he actually is a lawyer, because he is pulling Daryl Boone, helping the state tactics right here.
And then pending, once the autopsy was completed the next morning, was when I already knew I was going to meet with her again to discuss the autopsy results. So then we had another interview with her where she was Mirandized, and she went to jail later that evening.
While you were there on scene, I know at some point you saw her phone on the kitchen counter.
I did.
All right.
Or
And-
maybe on the microwave. It was somewhere in the kitchen.
All right. And at some point you went to Sarah Boone and you asked her for the password to open the phone.
We asked to go through her phone.
Did you ask Sarah Boone, can I have the password so I can go through your phone?
Yes, after she signed the consent form.
Okay. So not
Oh.
before?
So wait a minute. So she signed a freaking consent form. She signed the consent form thinking that they were going to find all this, George or Jorge being, hateful to Sarah. Ew. Just ew.
You didn't ask her before you asked her to sign the consent form, Sarah, give me the password to your phone.
Not that I recall, but I would normally have her sign the consent form first for her consenting to go into the phone and then gather the passcode or whatever it is.
Well, how would that have even come about then? I mean, how would you have approached her about signing the waiver to consent to search in the phone?
She called 911.
Welcome,
So
Derek.
I told her that we needed to corroborate her story as to what occurred.
Okay.
And so to do that,
And absolutely, this is a thought that I hadn't had, but absolutely they would want to corroborate that she called 911. And yes, this is probably a tactic to look deeper into her phone And if Sarah had been thinking strategically, she would have said, well, you're going to have to get a search warrant for this. I don't consent to anything. And then she could have kept her phone. Now they would have gone directly to whoever signs out their, search warrants and say, hey, we need a search warrant for this here phone. And, she would have lost it anyway. But this is a moot point. But it isn't a thing that didn't occur to me as to why they would initially even want to look at her phone, because I thought it was prompted by Sarah repeatedly saying, hey, I have evidence of him being mean to me. I have evidence of DV. Please look at my phone. So this actually is another really cogent reason why they would have asked for it.
I wanted to go through her phone.
All right, do you know about what time she signed the consent?
No, I don't think it requires a time on there. But it was when we were on the scene initially.
Was it prior to her interrogation in the unmarked vehicle?
Yes.
And after she signed the consent, did your testimony is you asked her for her
Yeah.
password and she gave you her password after signing the consent to search the phone?
Yes, I didn't touch the phone until my digital came.
All right. You're talking about the digital investigator, and they have the ability to open up the phone and search the phone?
With or without a password, yes.
But y'all utilized the password that Sarah had given, had you not?
I believe so.
Okay. And do you know how long it took for the digital investigator to show up after you arrived?
Oh, yeah, she didn't come until later. I believe around 7 p.m.
Okay.
is when in the CAD sheet says she arrived.
And there were two videos on Sarah's phone.
After I spoke to Sarah.
I'm sorry?
After I spoke to Sarah?
All right. So what I'm gathering from what you just said is,
Okay.
um,
Quick Mama Mo aside, if you have a crotch rocket and you are a younger male person, as Fundian says, who is a trucker on the road all the time, do not act like flippin' morons. Do not go at 106 miles per hour. Don't be dumbasses. Don't. Just stop it.
at some point, you asked or directed Sarah Boone into your unmarked vehicle where you interrogated her. Is that correct?
Where we completed an interview, yes, sir.
And your testimony is that you did not view the videos that were found on her phone. And I'm referring to the 2-minute video of George in the suitcase. And then some time went by, and I think there was about a 22-second video of George in the suitcase that Sarah took of him in the suitcase. Your testimony is prior to you putting her in your unmarked vehicle that you were not aware of those 2 videos.
You're welcome.
I did not go through her phone until digital.
Okay. And I read this as a mom who has 2 young drivers now out on the road, but also for the, truckers who work every day to bring us stuff. I have a greater appreciation having, interacted with a lot of truckers on here. Okay, don't clip that. Only in your dreams, Reddit and haters. But as people who have met a lot of truck driver, or as a person who's met a lot of truck drivers, the amount of crazy S that they see on the highway, it's just incredibly, incredibly scary. So thank you for all the truck drivers who are hauling stuff every day, getting me my Sailor Moon stuff because, well, it's a necessity, but also just giving us the things that we need.
Forensics came out and then went into her phone, and then she brought me over to her van to tell me about the videos and what she found.
All right, so your testimony is at the time that Sarah Boone was interviewed in your vehicle, that the forensic phone investigator had not arrived.
That too.
Correct.
Okay. Did you tell Sarah, I know we saw the audio once you get in the car, but did you talk to Sarah before y'all got in?
No, she's making that face because you said we saw the audio. You heard the audio. That's why saw the audio makes no sense and she's looking at you like a moron. Or her face looks really good when she's doing that, like, you're an idiot face. Mine just kind of looks like, I'm scared for you reproducing.
Got in the vehicle.
Of course.
And did you tell Sarah that y'all wanted to talk to her and this was routine protocol?
Yeah, that I wanted to have a
Welcome,
conversation with
ND,
her, and
Grandma,
once
to 12.
Once I had walked through the house and saw what I was working with, we would have that conversation.
Did you tell her that interviewing her in the squad car was routine protocol to your investigation?
I don't recall if I specifically said that, sir. This was 2020.
Okay. If she recalled that, would you dispute it?
Objection, improper question.
Sustained.
Your testimony is you don't remember saying that.
I don't remember specifically saying what. One more time. What is it that she claimed that I said?
Routine protocol.
I would not interview her, not in my unmarked car. So my routine protocol, sure, I would do that. I would
Okay.
interview her in a spot where no one can hear us.
And you would explain to her why you were doing that, wouldn't you?
Would I explain to her why we were sitting in my car?
Yeah.
Standing?
Yes.
No.
Well, you would have to tell her something.
I said, yes, we're going to go have a conversation in my car now.
Okay. And did she have any questions that you recall?
Okay, I need to order another brain slug. I apparently am functioning still at a too high level to understand what the hell this man is trying to get at. It's not like she bum rushed Sarah and, forced her into the car. No, it would be, and why is Owens relying on Sarah Boone as a reliable narrator? Sarah Boone, the woman who lies about everything and continues to say that, unintentional means not guilty. That's the person that you're trusting her memory? Okay.
You recall about what's this about? And you could have potentially explained to her that this is routine?
It was all explained on the audio recording.
Okay. But you agree you had a conversation with her before you got into the car with her?
Yes, I definitely directed her to get into the front passenger seat. And we were going to talk about it.
Okay. And you don't recall whether or not you said this is routine protocol to come into the car and talk to me?
Those words specifically, no.
Okay.
But I would have talked to her in the vehicle regardless. I would not have talked to her outside of my vehicle.
All right. Now, once inside the squad car, you were there with the other detective, Detective Lowen. Okay. And you read her the Miranda rights card, correct?
Yes, from my card, yes.
Do you agree that you didn't ask her the last question, number 9?
Objection, relevance.
Response.
Vague and ambiguous. He's trying to say she unlawfully interrogated without being properly read her Miranda rights, which she actually doesn't have to do. Again, until you are in custodial, from what I understand, and you guys know I'm not a lawyer, I'm just a mom who started watching a lot of trials, and that's kind of where we are here. But until you are in a custodial interrogation, I don't think they have to redo your Miranda rights. It's the exact reasoning that they didn't read Brian Boone his Miranda rights, because he was not potentially being charged with anything, at least to my understanding.
Judge, we're here on a hearing on the issue about the interrogation.
But of the case law that you provided to me, none of it stands for the proposition. Miranda identifies the 4 things that need to be addressed. Not one of the cases talks about that issue of reading that language at the bottom of the card that is in the motion upon information and belief. This is what it says. So how's it relevant for the purposes of today?
Well, it's relevant because this is the policy of her department.
But
Judge,
what does the policy have? But now we're getting away from the card to now the policy. There's nothing about the policy right now. The question is about what the card says.
Okay. The card is the policy, and the policy is the policy. They're intertwined. They refer to each other. Our argument is that she did not waive her rights.
But
Remain silent.
That's a different issue than what is on the card.
I understand, but it's a coercive question. about her not doing that, which was the policy of her sheriff's department. She elected not to do that. She wanted a statement from Sarah Boone at the scene. She wanted a statement from Sarah Boone at the sheriff's department. She elected not to answer a question that the policy says read verbatim from the card. Why did she not want it? Our position is it was an attempt.
You know what would be really cool is if you had all these positions and you had all these arguments, you would have cited cases in which officers didn't read the last line, or, you know, you could have even cited the case with the father who, okay, excommunicated him from the father club, the absolute piece of corrodated garbage human being that unalived his 3 sons, you know, with a shotgun. And that particular confession, part of it was dropped because the detectives didn't use, you know, he could have cited cases like that. The fact is that the state rightfully argued that they did not cite any case law, not even Miranda versus Arizona, in their, you know, motion to squash this. So I ask again, this man has always pretended to be a lawyer, right? Or am I watching the weirdest sitcom ever? Is this going to be a rom-com? Because if I have to watch 7 seasons for Owens and Sarah to get together like the nanny, I'm out.
Attempt by this detective to coerce Sarah Boone into talking.
On February 24th or on February 25th?
On February 25th, this interrogation ties into that one. She used the same routine protocol that she used for the second one. The first one, she claims that my client wasn't a suspect, wasn't a person of interest. At the sheriff's department, I'm sure, I haven't talked to her about it yet, but I'm sure she's going to say, yes, she was a suspect. Yes, she was a person of interest. Yes, we had probable cause to arrest her prior to her giving a statement. But what she said in terms of routine protocol the day before was what Sarah was relying on when she said routine protocol,
Okay.
when she questioned.
Detective Badass Beautiful Hair does not have to deal with the fact that Sarah relied on anything of her own. Why is Detective Awesome Hair responsible for what Sarah used to calculate her strategery? Ugh.
Question the detective about routine protocol the very next day in the interrogation room. And for her not to give that question goes to the totality of the circumstances as to whether or not my client, Sarah Boone, actually waived her right to remain silent. If she understood her rights and then she consciously and freely waived her rights. She was not asked that question. She was not asked that question in the car. She was not asked that question. But that totality of the circumstances comes into play for the court to consider, this court or an appellate court to consider as to whether or not that statement should be suppressed.
Any other response?
Judge, just like it's irrelevant what the sheriff's office policy is compared to what the Florida case law says about our right to not be compelled to give statements under our Constitution in the state of Florida or the United States and federal case law
Welcome.
and the state case law interpreting the United
Tanika's
States
2
Constitution.
cents.
The policy,
I am dead awful at names, so hopefully I got that right. Sometimes I get them right. Sometimes I get them horribly wrong. So welcome. And just for people that have come in fairly recently, I am on full petty parade. I have my brain slug from Futurama and to try to understand this legal case. And I am bringing all the petty. I am bringing all the petty, all the mean. I do not like Sarah for a multitude of reasons, but mostly because she has never, ever cried. At least that I've seen. All of her, you know, sympathy, sorrow, and, you know, sadness has been for herself. And, you know, quick personal aside, as a person who has had to tell children that their, you know, one of their parents isn't coming home, and, you know, imagining what Jorge's or George's, I've heard it said both ways, imagining the incredible loss of their father that for these children, and all Sarah could say was, "Are you trying to make me feel bad?" No, I don't like Sarah. Yes, I don't hide it. It is in fact malicious. It is in fact intentional. But just trying to give you guys a heads up, I am a mom of 6. I do not know legal, lawful law, but I just give my 2 cents, and here we go. Back to the craziness.
Is irrelevant, and the officer's subjective intent is completely irrelevant in a motion to
Anyone
suppress.
can join the
Just like it would be
pettyverse.
in a traffic stop under Wren versus United States. What matters is objectively what was spoken to the defendant. And I would ask that we honor the local administrative order and call people by their surnames and not their first names. What matters is that the defendant
Thank you, Rachel Lee.
read what the case law requires. Anything about the policy, anything about the officer's subjective intent is completely outside of all the case law submitted by both the parties.
Last bite at the apple.
I'm sorry.
Last bite at the apple. Last bite at the apple. Any other argument?
Judge, we're talking about the totality of the circumstances, whether it was coerced or not. You can take any technique or a non-technique, something that you use or don't use, to establish whether or not it was coerced or not. The fact that she didn't read, do
Wait.
you understand?
So you can use a technique or not a technique. So anything in the universe, any way possible. And I would have to have the eyesight of Mr. Magoo on a bad day to see where you're coming at with this argument. What in the world?
Understand the rights? Do you understand these rights, which is the form, the Miranda warning form? Do you wish to talk to us at any time? That's on the waiver affidavit. On the other form, which is the policies form, it says, do you understand these rights? And then the question number 9, do you wish to talk to us at this time?
Objections overruled.
Thank you. And you're referring about surname. What do you mean by that? You mean,
That means last name.
okay, what did I say?
Keep calling the
Jesus giblets Josaphat. Does this man not know what a surname is? This man graduated before No Child Left Behind. Is this the case? Did he take Common Core math? What the hell? What's a surname? I have Sir, you were there when surnames were invented because, families had more than, 5 generations that were able to survive. What the hell is wrong with you? What's a surname? Dear Lord Giblet,
defendant by
I'm
first
done.
name.
All right. Can I say Sarah Boone?
Either Miss Boone or Sarah Boone.
Thank
that's
you.
fine. You may proceed.
Have you had a chance to look at the standardized Miranda card issued by the Orange County Sheriff's Office? Do you agree that you did not read the 9 questions to her in your squad car?
All 9 questions?
A little bit, me
Correct.
too.
No, I did not read all 9 questions.
Do you know how many questions you did read to her?
8.
Okay. And the question you omitted is question number 9. Is that correct?
Yes, it's actually not on my Miranda card.
I'm sorry?
It's not on my Miranda card that I read. Continue.
What do you mean by that? It was the card that you read, it was not on the card?
Number 9. We have multiple Miranda cards at the sheriff's office, but yes, that is the in reference to the policy. Yes, that's the policy.
Well, somebody dropped the ball somewhere. Did you fail to get?
Sustained.
That's it. Someone find Kinko's. Archie down at Kinko's is getting fired. He cut the Miranda cards wrong before he put them in the laminator.
Did you fail to get the most updated card, or how did that happen, that the 9th question was not on your Miranda rights card?
I've had that card since I started being in sex crimes in 2013.
Have you become aware, as it relates to filing this motion,
I've become more aware, yes, that there is that card.
have you gone and gotten the updated card?
Objection, relevance.
Sustained.
When y'all took her phone, Detective, did you tell Sarah Boone that you would be returning to her apartment the following afternoon to give her phone back?
Yeah.
You did not tell her that?
No, I listened to all my interviews, everything that's been audio recorded. No, I did not tell her that. We had plans to meet at the sheriff's office.
Or tell me what you understood the conversation was as it relates to her getting her phone back.
I'm sure she asked when she'd be getting her phone back, and I didn't give her a detailed timeline. I said that.
Okay. Police are allowed to do this. We have all seen, on our local news, Johnny, head talky guy going, well, today on, criminals getting their just desserts, the local sheriff's office decided to play a scam on some scammers. I mean, we've all seen those on our local news. This is what cops are allowed to do this. Are you new to the justice system, sir? I mean, hashtag me too, but
I don't even know if I told her that I decided to write a search warrant on it because I don't need to tell her that. It's evidence in a crime. I'm allowed to take it, and so I took it, and I wrote a search warrant for it.
Okay. But you don't recall ever having a discussion with Sarah Boone about when you were going to return her phone?
good point.
Okay.
It's a game of
You
legal
recall
tag.
her calling you later that evening on your cell phone? From her husband's phone? You don't recall that conversation?
Her ex-husband, no. Owens, I'm not going to let you get away with this. Sarah Boone was dating George for 3 years. Sarah Boone was divorced from Brian for 1.5. Now that math doesn't math, and I don't do math well, but even I know that doesn't math. So that was her ex-husband. And Detective Candy, I hope you changed your cell phone number because holy crap, Sarah Boone has your cell phone number. Run.
Conversation, she called you later that evening?
Do you have documentation of the phone call?
I have her testimony.
Oh, okay. Well, I don't recall the phone conversation.
Excuse me?
I do not recall the phone conversation.
And yes, Rog Vortex, she
You
wants the
said that y'all had
interrogation
some
throw out because it makes her look
discussions about
guilty
Sarah
and
Boone
won't
coming to
support
the
it.
station. Was that talked about the day of this event or the next day with Sarah Boone?
It was talked about before I left the scene.
All right. And
Oddly,
did you
yes.
relate to Sarah Boone that she needed to come to the sheriff's department the next day to retrieve her phone?
I don't know if I specifically told her about retrieving her phone, but she knew that I was waiting to hear about the autopsy results and that I would probably have more questions.
All right, so you believe you told her that night, I need you to come back, maybe or maybe not about the phone, but I may have some more questions for you?
Something along those lines.
Okay. And when was it that you actually saw the 2 videos from Sarah's phone? Was it that evening after the interrogation in the squad car?
I've already answered, but yes, it was after the interview.
All right, and was it while you were on scene?
Correct.
Okay. And did you attempt to talk to Sarah
know, it's
again
a thing
about
of
that
beauty.
at that time? Okay. And so
Welcome,
did you
Rachel
let
Lee and
your detective partner know about the videos on Sarah's phone?
Objection, relevance.
Overruled.
Did you let your partner know about that evidence? Okay. And did y'all discuss that issue?
Objection, relevance, work product.
Sustained.
At some point, y'all had to, were y'all working together or were you making all the calls or were y'all making joint decisions?
Objection, relevance, work product.
Sustained.
Tell me, Detective Good Hair was the shot caller. I need this in my life. Come on, 2024 shot caller. I just need it. Like, were you the OG of this?
Ma'am?
There's no pending question at this time, ma'am.
At some point, did you form an opinion as to whether you had probable cause to arrest Sarah Boone?
Objection, relevance.
Overruled.
Yes, at some point I did.
Did you make that decision by yourself or was it collectively made by others with the department?
Objection, relevance.
Sustained. You don't need to answer anything.
Detective, at what point did y'all, that next day, I think you had her coming in the afternoon?
I believe it was around 3 p.m.
Did y'all work on trying to get the search warrant for the phone?
I got the search warrant for the phone, and I believe I submitted it that evening. I would have to look at it though.
Okay. Do you know what time the search warrant came back signed by the judge?
It's documented in my investigator report, but I don't know.
Okay. And would it be fair to say that you told Sarah to come in later that afternoon or the next day?
Yes.
Okay. And would it be fair to say that you worked on the case that entire day until Sarah Boone came in?
Yes, I attended an autopsy in the morning. That's why I asked her to come in at 3.
All right. And what time was the autopsy that morning?
It starts at 8, but I didn't probably get till 10. It takes quite a few hours.
Okay. And were you there alone with the medical examiner or were there anybody
Okay.
else there?
What in the lack of agency are we trying to do here? And normally I don't take up for this whole, girl boss thing, but is lawyer Owens saying that the little woman, the detective who used to work in, SA crimes, had to talk to her big, strong detective man partner to figure out this crime? There was a suitcase. There was a dude inside a suitcase, and only Sarah was in the house. Again, you don't need Nancy Drew, Nancy Grace, and the Hardy brothers to figure this out. The condescension.
I don't recall if Detective Long was with me or not, but yes, of course, there's doctors there.
Okay. And so in terms of your determination as to whether or not Sarah Boone was a suspect, did she become a suspect after you watched the video, the 2 videos from her phone the day before the autopsy?
Objection relevance. Custody is not disputed on the February 25th statement.
How's this relevant? If the issue is knowing an intelligent waiver, the sufficiency of Miranda and coercion, what does the formulation of probable cause have anything to do with anything?
Well, I wanted to bring out the fact
Well,
that
Tanika's 2 cents also. So his machismo is off the charts. Why not just call her little lady after each question? So we are robbing Sarah of her agency because this woman, but under the guise of a bigger, stronger, smarter man, was able to trick Sarah. So unless you're trying to say, Owens, you are taking Sarah Boone's right ideas for strategery. The last time she played a game of strategy with anyone, he ended up in a freaking suitcase. Perhaps not play games with Sarah Boone. And again, this was not a whodunit case. This was it seems pretty likely that something isn't adding up here. And there's video. And she signed a waiver and she signed this all off. So unless you're saying that Sarah, the Mensa member, was outgunned by a woman who couldn't, think hard enough for herself to ask for a search warrant her own self, sir, miss me.
they had already made a decision before she came in for the interrogation on the 25th that they had probable cause to arrest her. So that if she, either
Haley Mouse, here, I almost felt sorry for Owens before he opened his mouth. He opened his mouth, because you volunteer for something, and I would think you would at least do a cursory look at this case, a cursory look at how in full deficit this judge is, and realize that you're coming in is not going to probably get you a continuance, and really be real with Sarah about what her options are as a lawyer, not take every crackpot idea that Sarah's had for, 8, 9 lawyers that said no. It's absolutely, if he got this case for, publicity or anything, he's ending up looking ridiculous. And I don't know that this is going to get him any more retainers.
either didn't come in, they were going to go arrest her that day, or B, if she did come in and she exercised or invoked her rights to remain silent, that they were going to arrest her anyway, that they had already made a decision that she was the prime suspect. They had probable
What does that
cause.
have to do with any of the three issues that are raised in the motions?
It's whether or not she was in custodial interrogation, whether she was free to leave.
I don't know that that's being disputed by the state.
I think my response
That's my understanding. The state's
Okay.
not disputing that there was a custodial interrogation, which is why, on February 25th, which is why Miranda was provided prior to that.
Judge, it was provided the day before, and she's just testified she was free to leave at any time.
Okay.
So the Miranda was given on two.
Again, you are making the worst possible case for your case here. So, on one hand, you are trying to say that the police coerced her and were acting shady. But when they didn't have the evidence or again, they didn't have any video, they just thought it looked, a bit sus, they let her go, thereby showing that they were following the sort of spirit of the law where you cannot arrest someone unless you have probable cause. It's absolutely insane to see him try to argue both of these situations in collusion with each other to explain that the cops were coercing her or being mean to her. And welcome, Kova42. I do love Judge Kranick, but I do want a paternity / brother test between him, Ted Cruz, and Governor DeSantis, because I think that there is a possibility that they are strongly genetically linked. Thank you. I actually got it on Amazon. High Pain Day Me sometimes buys me gifts. I will have to show you guys the other one that apparently I also bought me. It's just like when Nicholas Starro gets, presents from Drunk Him. I get presents from High Pain Me. Although we have generally come to like a $20 buy limit. Unless, of course, there's quad pay, and then it's $20 4 times.
Two separate occasions. She wasn't in custodial interrogation. Detective, am I right? The day.
Well, hang on. Before we ask any questions, let's deal with the evidentiary objection first. The objection is sustained.
Thank you, boss lady.
You may proceed.
All right. Ma'am, you would agree that when Sarah Boone arrived that afternoon for the interrogation, she was not free to leave.
She was not.
Excuse me?
She was not going to be free to leave. No.
Okay. And so if she would have remained silent and exercised or invoked her right to remain silent.
Oh my God. Do you think Sarah is thinking, when I get my hair and makeup, I'm going to look prettier than her? I'm going to look so much better than her. She's over there trying to use her feminine wiles on my attorney. I am going to object. I am going to object now. She's trying to seduce my white knight who's riding on a Don Quixote dead donkey pretty much, but he is tilting at windmills.
She would have been arrested anyway. And that was based on your investigation that you had the night before at the scene. It was based on her statements that she had given you in the squad car. And it was based on the autopsy that was performed the next day that you were present for. And it was based on the 2 videotapes that you saw from Sarah's phone.
objection for relevance as to what the probable cause basis.
Sustained.
You had all that information before you began your interrogation on the 25th of Sarah Boone.
I had all what information?
All the information that I just related to you before you began your interrogation of Sarah Boone.
On February 25th?
That's correct.
Yes.
And you would agree that you wanted to speak to her on the 25th.
Objection for relevance.
Overruled.
Good point, Rachel Lee.
And would it be fair to say that you wanted to get state?
Once the authorities see your snuff film, you have to assume you're not going to be free to leave. Well, she thought she deleted those. She should have used Bleach Bit.
Statements from her relating to the injuries to George Torres from the autopsy.
Objection for relevance.
Overruled.
Yes, I wanted to have a follow-up conversation in reference to what she told me the night before and in reference to the injuries that she failed to mention.
And you also wanted to question her about the 2 videotapes that you had found on the phone.
Overruled.
Yes, I do
Okay.
want to show her the videos.
And you agree, in your opinion, the 2 videos and the autopsy were inconsistent with the story she had given you in the squad car the day before.
Objection.
Overruled.
The videos, I'm sorry, repeat your question one more time.
You would agree that the autopsy results and the videos that were extracted or taken from her phone, recording George, those 2 pieces of evidence from your investigation were inconsistent with the statement that she had given the day before in your squad car.
Same objection for the record.
Overruled.
Yes,
And I believe that's ultimately the reason you arrested her, because of her inconsistencies.
Objection. Irrelevant.
Sustained.
Now, you said you've had a chance to review the interrogation video at the Orange County Jail on February 25th of 2020.
the Orange County Sheriff's Office.
The Orange County Sheriff's Department. And also, I believe the state attorney had it transcribed. Have you had a chance to read the transcript?
I have not read the transcription. I watched the video and the audio.
Okay, have you had a chance to look at my motion where the question and answers are typed out, at least the first minute or so?
No, I have not looked at your motion.
Okay. Do you recall you saying to her, I'm going to have you sit in the green chair?
Objection. Best evidence is the recording.
He's right.
Okay.
Objection sustained.
Okay. Do you agree, prior to reading Miranda,
Yeah, that's
that you
not
mentioned to her
purview.
that you had received his autopsy and that you were going to read her rights again, but that we had to talk about that, referring to the autopsy?
Objection. Best evidence.
Sustained.
Do you recall making some comments to her?
Owens, did you read the transcript? Because it doesn't look like you read the transcript. Again, one of my biggest fears, if I were an attorney and this face is contempt of court, I am bold and underline in caps on all of my facial movements. So that's why that's out. But did you read the transcript? Because you don't seem to remember what the things that were said were. Or were you taking Sarah Boone's word for it? And that superseded anything that you actually saw in a transcript.
Or prior to reading her the rights?
Objection. Best evidence.
Overruled.
Good point, Wolfram.
Yes.
Is it the policy of the Orange County Sheriff's Department to make any statements to them about the interrogation prior to reading Miranda?
Now,
Overruled.
what I will say about this is I have watched a lot of interrogations. They've gotten me through some bad pain days, but also I do shameless self-promotion plug, Legal Shenanigans Theater. And I think our first Legal Shenanigans Theater was Not Without My Suitcase, the Sarah Boone interrogation. And a lot of it's more of a fun, smartassy sort of, interrogation read. We did Chandler Halderson, and we are now on Daryl Brooks, King Douche of, all douches. But a lot of interrogations that I've watched and from former police officers talk about the read technique where you build a rapport. Now, where you are supposed to insert Miranda into that rapport building, I don't know, but there generally is a good kind of bifurcation in the interrogation if they are using the read method to where they kind of have this rapport building where they just kind of talk like, I'm so and so, we're just here to talk about this. But since, and then they can kind of chit chat for a little bit. But because we're here, I do need to read you this, this, and this. And it's usually the Miranda rights, and then have them sign a waiver, stating I can read, or, trying to assess their education level if they need to break down the Miranda rights, further. And that is also why going through, the state responded in, this Miranda warning fakakta, thing, that standard verbiage of how one reads the Miranda warning needs to be flexible, because police are going to encounter people that, like Sarah, are Mensa members, and then also, like Sarah, don't actually understand what that means. So you've got that whole thing. And for the love of all that is holy, take care of it. Has to be flexible so that you can meet people where they are. It's not something that can be written in legalese or even that. That's why they do generally ask, like, what's the level of education that you've received? What do you understand? These are not things to trick Sarah. These are things that they generally do. And as a person who isn't in law enforcement but has watched enough interrogations to really want to tase someone, which is also a reason I'm not a police officer, it really is that simple. They build rapport generally.
One more time.
I assume that's not the first time you've read Miranda to a suspect.
Oh,
Sustained.
the condescending little butt monkey here. Sir, you are taking Sarah Boone's words as your true north. I cannot even explain to you how wrong that is, but you want to be condescending? How many times did you read the transcript, sir, and you just got objected to about 18 times because you didn't remember the transcript right? You might want to tone it down, asshat, because you're not looking too smart from my perspective either. But, I can condescend to anyone because I am Sailor Mo.
Let me go back to the first question then. Is it the policy of the Sheriff's Department not to ask any preliminary questions prior to reading Miranda rights?
Same objection for the record.
Overruled as relevance.
You would have to show me the policy that you're referring to, but I was not asking her any incriminating questions during that time. I was explaining to her the purpose of the interview.
Well, have you ever been, I understand you must have undergone some training on Miranda rights and how to interrogate somebody.
Owens, did you undergo any training on how to write a motion citing case law?
Sustained.
How long have you been with the Sheriff's Department?
Oh, I need to go back and just see that and just pause it on that face of, I will destroy you.
Sustained.
And there we have it. We're moving this face, this oh hell no face. She is now calling on all of the, all of her filters to keep what is going through her head from coming out of her mouth. I know that face. I've seen that face on myself when I hear some ridiculous stuff from my children. So I know that face.
How long have you been with the Sheriff's Department?
Since 2013,
How long have you been a homicide detective?
over 6 years.
Okay. Have you ever been trained or told to ask or not to ask any statements or any questions
Good
prior to
point,
reading Miranda
Michelle's
relating
Wikipedia
to them
madness.
talking to you?
Objection relevance.
Sustained.
Hells no, Sarah Adams. We do not mess. I've decided to change her to Detective
Can
Good
you
Hair.
tell us if you recall saying anything to her prior to reading her Miranda?
I recall briefly talking about getting the autopsy results, and then I wish to have a conversation with her.
All right. Do you recall again reading her Miranda rights to her on video?
Yes.
Do you recall, again, omitting
Yes.
question number 9 on the standardized Miranda rights form for the Orange
I
County Sheriff's
know.
Office?
Overruled.
I did not ask for question number 9.
Okay. Do they have a Miranda cards form in?
Y'all, this is a total Megan Fox hair aside, but I'm now looking at that and thinking, okay, which wig will best fit detective, awesome hair? Because I have several wigs that I'm thinking about right now. And now I'm like, oh, I get to go style a wig. I'm showing up as detective, great, awesome hair, for the whole time. I might need to get my eyebrows figured out by someone professional, but I'm here for it. Also, I need to get a little tanned. That won't happen, but everything else. And I will be ordering a satiny red shirt because we're not forgetting our other detective.
In the interrogation room? So you would have had that on your person?
Oh, and I also have a really, really bad feathered wig that I'll be using because I have no doubt that Sarah will show up with some sort of feathered coif at some point to try to show, Detective Awesome, that she looks beautifuler. So I will have a hot mess ratchet, Farrah Fawcett. Yeah. Yeah. I'll have to figure that out. Although I'm saving all of my, sidearms for the tactical walker that I'm going to be bedazzling later. Mailman, yes. Well, she had 4 years. That is awesome. I should be doing one of my mini crafts because I plan to start a new craft project for Sarah Boone's trial, but I need to set up my whole overhead mount and all of that jazz.
You may.
Yes, this is our waivers and affidavits.
Is that filled out waivers and affidavits?
It's filled out by me, but there's something highlighted that I did not do.
Absolutely. Absolutely.
Is that form filled out as it relates specifically?
We're talking about just this top, right? Okay, I'm sorry. It does it.
If I'm not mistaken, I think they're and I could be very wrong. I mean, I've never watched Orange is the New Black or, anything really, but I think that there are maybe certain inmates who are highly trusted that can work in beauty salons, but I think that is in prison. I don't know what the jail, since jail is generally for short-term housing and prison is more for long-term or jail pre-trial stuff. And then also, prison might have more facilities. I don't know. Maybe she's allowed to, once in a while, maybe student hairdressers come in. I have no idea. That is a good question. I'm just wondering how much hair gel she has to use for that, because I have a Sarah Boone wig, and the amount of hair gel that I had to put on, it, there are some countries missing a whole can of White Rain, is all I've got to say.
Is that form, is it filled out as it relates to Sarah Boone?
In case, yes.
Is that her signature or what?
Yes.
Did you see her sign it?
Yes.
Is that your signature or what?
Wait, actual hairdressers co-signed the baby ponytail?
Sent
They must have been new.
form?
The consent to search, yes.
On that form, is there also the lawyer voice?
Yes.
That is a form that's standardized by the sheriff's department.
Yes.
You did not read a Miranda from those rights?
From this piece of paper,
Yes.
that's audio and video recording?
Yes, I have actually done several dramatic readings, Tanika's 2 cents, as Sarah Boone. It is very odd to get into that headspace. I must tell you, it really is odd to be full of unearned confidence and self-assurance. I mean, I can play it for a couple days, or a couple hours, but I have never ever encountered a person that is absolutely so self-assured and so very, very wrong. The Sarah Boone wig was actually so I may have a bit of a wig problem. You guys, I have 2 hanging clothes racks full of wigs, and it was actually a shorter pixie cut that I kind of worked on. So yeah, it's insanity. Mr. Mo doesn't ask questions anymore. He's just like, that's a tax write-off, right? Oh, I hate those check-ins. Thank you for lurking and listening. Her truth is all that matters. Had she, and here's the sad thing. So if Sarah had humbled herself, had actually looked inside herself and see what she cost George's family, his friends, and just the opportunity for George to maybe get a better footing on life, I honestly think that it would almost nearly, and I am not a psychologist, but I do think internally, if she were to actually look within herself and at the deepest kernel of herself, take responsibility, it would be so incredibly psychically painful for her to have to watch herself and understand herself from a more human perspective and see where she was actually wrong, that I think it would I think she'd go into a coma. And thank you, Wolfram, for gifting 10 Mo in the Deep End memberships. And those went to Michelle's Mixed Media Madness, Haley Mouse, Shiloh Gal, Tony, Tanika's 2 cents, Heidi, Trina, Jung Forever, and Shantae's Inferno and Dizzy Grenade. So congratulations. Welcome to the Church of Mo. We have dark chocolate and sarcasm and maladaptive coping behaviors, but we do allow those. The only thing we don't allow in the Church of Mo is those plastic audio assault weapon recorder musical instruments. As a mother of 6, I can tell you I have been held in listening hostage as 17 children try to do hot cross buns one too many times. So those are illegal in the Church of Mo. And too much patchouli oil, you can wear a little bit, but please wear deodorant too. Those are our only really 2 big rules. And I will write up those tags probably after the stream.
Yes.
So we can keep going. I think she has
Same objection to the relevance.
So I'm not buying it. I would think that she would be barred from reaching out to the victim's family. That's my only guess as to why she hasn't reached out to them. I think it could be seen as witness intimidation. So I think that as dumb as Sarah has played this all, I think she hasn't crossed that line because I think that there would have been protective orders put in place. I think Sarah is at least tangentially aware, even if it's on a very, very lo-fi level of how she is perceived. And I think she realizes what a absolute bad idea reaching out to the family would be. Or she was told not to. But she doesn't exactly follow the rules, so I'm guessing it just hasn't occurred to her yet. But I think if the trial starts going badly, we could see Sarah really act. Owens better watch his back. I'm just saying, Owens, I would keep a side eye on where all the pens are on that desk because she's going to pull a business if it starts going down.
As far as it being a consent to search her phone, we're not disputing that she was in custody on February 25th, 2020, when she gave a statement to the detectives. And again, under the case law, there's no requirement
Rachel
for
Lee,
this
good one.
question 9. Under any state case law regarding the Florida state constitutional right to not be compelled to testify against oneself, nor any federal or state case law regarding the United States Constitution, the Fifth Amendment applied to this state through the 14th Amendment that requires that question
I'm
to be
here for
read.
that.
It does not go to the totality of the circumstances of the voluntariness of her waiver of her Miranda rights.
Good response.
Judge, obviously we disagree.
Well, then where's the case that supports that? Because as I addressed previously, I read all the authorities. I mean, State versus Owens, State v. Thomas, Powell from the United States Supreme Court, which reversed a Florida Supreme Court decision. I'll talk about what's required by Miranda. And that question number 9 that you're focusing on isn't included in any of those.
I understand that,
It's
Judge.
the right to remain silent, the right to an attorney before and after questioning. If you can't afford one will be provided to you. Everything you say can and will be used against you.
Come on, eyebrows of justice. Let's end this. Let's end this now. Although the only thing I would say is that as long as you don't copy my idea of a romance, sob-sit style between her and Daryl Brooks, because my first book will be, you have jurisdiction over my heart. And then the next one will be, I'll drive my land boat to see you wherever you are. I still have nightmares seeing that clip. Although that was probably that was the happiest she ever looked. Ew. It made me scared. Again, maybe it's just me, but anytime Sarah Boone smiles that big, I imagine that she just got done watching the ending to Old Yeller on repeat for like an hour. Or she watched, Corella DeVille when she was trying to design puppy capes. Like, that's just what I think about making her smile. So it creeps me out because, well, she's Sarah Boone and she's smiling. That means something very bad for humanity.
Against you. Those are the things that Miranda highlights. The Miranda opinion itself says that. So what does question number 9 have anything to do with those things if the state case law and the federal case law, including but not limited to Miranda itself and Powell, and then the state case law of Thomas and Owens, all of which were provided either by yourself or by the state, identify what's required, and that's not one of the requirements.
She has a duty to read the rights.
But they were.
Okay, I want to finish my argument.
Okay.
She has a duty to read the rights. She has an obligation to ensure that Sarah Boone understands her rights by asking that question. Do you understand the rights I've just read? And then there must be a waiver. Yes, I understand the rights, and I agree to speak to you now. So for that to be freely and voluntarily given, that statement, there must be a conscious waiver of the rights. The problem with the detective is she reads the rights, do you understand the rights, and then she goes right into questioning.
Okay, you just learned that her card, now again, it was probably not current to standard operating procedure now. But if the department does not make it a priority to hand out the new updated Miranda cards to all of their detectives, then I guess that means by your logic that all criminals should be, set free because they weren't asked, do you understand this? I I will say, given all the things and all the jokes I have made to Owens, uh, he is vigorously defending his client, but he's also vigorously pissing off the judge. And what is the number one rule that we've learned in LawTube and adjacent LayTube? That is, do not piss off the judge.
She goes right into questioning without saying, do you agree to speak to me? Understanding your rights, do you agree to speak to me now? That goes directly to whether or not it was freely, voluntarily, and knowingly given, the statement, and whether that waiver was. So under the totality of the circumstances, I think that evidence is relevant. It's the policy of the Sheriff's Department. Obviously, she had an old Miranda rights form, but she failed to read what we perceive as a critical question, and she's going to testify about what she perceived at the time that the detective failed to read that.
I believe that in the most current standard operating procedures, from what the Owens is saying, is that yes, the new card has been updated to ask the ending question 9, but it really doesn't. It really doesn't make the point. Again, they have satisfied all of the major Miranda issues. And he cited no case law that says by not reading the most current understanding of Miranda, then Sarah Boone gets to walk up out of here free. That is not how any of this works, sir.
That question and how it ties into the case. I understand that all they have to read is those 4, but I think under the totality of the circumstances standard that this court has to apply, that should be a consideration the court should consider. I know it was an honest mistake. She had an old card, but still, I feel.
Owens, do not even attempt to be, understanding after you just basically said, are you new? Are you a new hire? Do you understand how to read? Do you know how to read Miranda? You just got done calling her like a moron that couldn't do anything without her male detective, present. And now you want to say, it was an honest mistake. But piss off, Owens.
Feel like it should be considered in your decision.
Anything else, Mr. J?
It's essentially the defendant stating that they want to make new case law.
I'm going to sustain the objection.
Your Honor, this is mean to my client. And I think you should think that my feelings will be hurt if you don't, rule for me. And if my feelings are hurt, I'll go on court TV and say that. The brows of justice say pound sand.
The objection is relevance by virtue of the decisions in Thomas 351, 7th, 3rd, 197, and Owens 41, 7th, 3rd, 352. There's, it's not relevant as to what the questions need to be asked for the purposes of whether a sufficient Miranda waiver was given.
Do you agree, Detective, that after you read her those Miranda rights?
Okay. Come on, internet. Did they?
Or when you read her Miranda in the squad car?
Okay. Sorry, I don't know. We missed a little bit, but it kind of glitched out for a second. So given my computer skills, let's hope it stays on track. No, I watch the Sarah Boone interrogation all the time. for a while because I would just use my rage to fuel me
That's
to
all the
do
questions
stuff.
I have at this time.
Any redirect?
No, thank you.
All right, can this witness be released?
I'd like her to stay.
All right, subject to recall. Thank you. State, you may call your next witness.
No additional witnesses or evidence on this issue, Judge.
Okay, all right. Anything from your side of the ledger, sir?
Judge, I would like,
Y'all, it's like, okay, I get this because I totally watched the Sarah Boone interrogation all the time, and I will probably rewatch this hearing. My only explanation is it's like when I watch my 600-pound life when I'm walking in the mornings, or when I watch Hoarders when I feel like my room's a mess. I mean, sometimes seeing a bigger train wreck than your current struggle bus is kind of comforting in a weird way. It's probably maladaptive. It's probably not what therapists would say, but but it's how I deal with things, and I'm the head of the Church of Mo, and I say it's totally fine as long as you're not mean to people in real life and you don't put any mean comments in the in the comments section.
you stipulated to.
No, I don't object to the authenticity.
Judge, I would like to introduce.
I love him. I love him so much.
Just that one.
Oh, she has to be. I'm waiting for the absolute
What is it that's been
ratchet
marked
wig
as
that's
defense
coming
exhibit?
in. Yeah, I will say I have been incredibly impressed with the judge, how much time he puts into, his own research, understanding the background of this incredibly long-standing and complex for the amount of shenanigans that has gone on in this case. So I will say that Judge Kranick has been very on top of it, and I've actually enjoyed him, calling both sides and really keeping both sides on task, and just looking very professional, very put together, and prepared. So I have no problems with, brows of justice. Sarah Boone over here trying to steal a pen. Ma'am, I see you. They better check her ass for that pen. She is trying to... Don't try to be sneaky. I see you trying to take that real pen, that real Bic over there. Gonna call the Orange County Sheriff's Office and make sure they searched her for a Bic.
Is it the form as of now, or is it the form as of 2020 when the... Okay. Can I see it for a moment, please? Thank you. Any additional argument with regard to the state's relevance objection?
Same argument.
No, I'm sorry, Mr. J, I wasn't specific enough. Mr. Owens, to you. Any additional argument? All right, I'm going to...
Kova 42, I don't want to know what the hell she's doing with like 36 slices of cheese that, kept getting her in trouble on her prison notes. And the actual real problem is that if she actually does want to go ahead with this, this battered spouse syndrome, she is going to immediately tick off so many people. I don't know that they're going to find a jury that is going to be at all sympathetic to her. I think if you... I don't understand what the strategy is going to be for the defense when you go to voir dire and ask, does anyone have experience with a family member or anyone, with DV? Well, anyone who's actually walked and lived in an abusive relationship, male or female, is going to take one look at Sarah and not find her at all sympathetic. And then those of us or those that maybe haven't walked through that are going to have that feeling. Again, it's that feeling, you can't describe it. You can't really externalize it with words, but something is off. It's like, what is prawn? I can't exactly explain it to you, but I know when I see it on a hub. I mean, there is something so intrinsically predatory about Sarah's whole demeanor that it's just not going to work. This is the dumbest play that will ever, ever go down in legal history. It's just out of ridiculousness. And I kind of do hope they spill cold water on her just to see if she'll melt. But that's mean. And this is also why I'm not really in any sort of legal profession. I try to push play on
I'm going to sustain the
StreamYard. That
relevancy
won't work.
objection for the same reasons the court articulated previously.
Oh my God, she does. Okay, Wolfram, I'll give you Chuck E. Cheese, but I'll raise you Showbiz because she kind of looks like that bear, that really creepy animatronic bear. I think there was maybe a division between Chuck E. Cheese and Showbiz. So I remember the weird kind of bear that looked also kind of like it was mixed with something else. But she definitely does look like if Teddy Ruxpin had a couple really bad years.
And Mr. Owens, you had one additional exhibit as well?
This is a composite exhibit, Judge. It's the policy of the Sheriff's Department.
Have a great day, Heidi. I hope really you get some rest and yep. Oh, please, that would make my day.
Do you know what page specifically those policies are on?
Page 14 of 22. And I'll give you two more
Okay.
pages.
So this is interesting, and I will have to ask my lawyer friends because I learned this in the Darrell Brooks trial, but there is a special subpoena that I believe you are supposed to serve county officials with, or anyone, if you would like them to bring in their standard operating procedures or company procedures and policies in paper form or in some kind of form. And I believe it is a subpoena ducis tecum. I am probably pronouncing that very wrong because in my head it's subpoena ducis nucum, which is obviously wrong. But it is, I wonder if they had to do that and that was something that we didn't get. But it was just weird. And yes, Showbiz did have animatronics. They had this weird bear that looked like it was part bear, part brown bear, part chimpanzee. It was really weird. But yeah, it was nightmare fuel, like most of the 80s children's shows. Let's not get started on Dark Crystal and Labyrinth. Jim Henson, you have a dark sense of everything. Good Lord.
Is it beginning of paragraph 4, waiver of constitutional rights?
Yes.
Oh, yeah.
Okay, I've read pages 14 and 15.
All right, Judge, and then you go to 13 of 28.
13?
13, well, it's the next,
Oh, there's two different sets. It's a
Split up.
composite. My apologies.
it's split up.
Got it.
14 or 28 at the bottom, P.
I love Jim Henson. I'm just saying, as an 8-year-old, the Skeksis scared the ever living crap out of me. And then New York decides to make their governor one, which scares me even more because I didn't even know Gelflings existed. And then Labyrinth was great, but can we all just, agree that David Bowie's codpiece was a main character in that movie because everything had to be filmed about crotch level because of the puppets. So it's already a story about an old man who steals a baby to get with a 16-year-old. Granted, it's David Bowie, so I kind of allow it, but that shows more about me being the problem. And also, they ended the dinosaurs on everyone dying because of climate change. Not saying I don't love all of these things, but yeah, I have a couple questions. Although, if you try to tell me the Muppet Christmas Carol is not the best Christmas Carol movie out there, I will fight you. In Minecraft.
And then it goes on to the next page, 14 of 28. Specifically 2A on 14.
It is the best Christmas Carol ever. And Tiny Tim lived.
Anything else?
No other argument, Judge, other than what we've talked about.
Anything further?
Same arguments.
Okay, all right. I'm going to overrule the objection as to relevance as to what was pre-marked as composite C. And that'll be received into evidence. Over objection as states 1. I'm sorry, defense is 1. Any further witnesses, evidence, or testimony, sir?
Judge, I'd like to call Sarah Boone.
Ms. Boone can approach the podium.
Oh, dear Lord. It's the moment we've been waiting for.
She was previously
Here
sworn.
she
Yeah.
comes with the bowl cut. Miss Congeniality. Be careful if she gets a suitcase.
Yes, sir. Hang on, the deputy's got to move her. Ma'am, you've already been sworn. Counselor, you may proceed.
And would you please state your full name?
Sarah Boone.
Well, you're going to have to speak up or move the mic.
Sarah Boone.
Ew. Okay. I don't think we're going to need the 7 seasons of The Nanny to get their romance. Looks like we're going to get about 1 season and they'll declare their love for each other. Again, ew.
Where are you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020? Was that the date of this interrogation that we're here for on this motion?
Yes.
All right. Let me take you back to the morning of finding George Torres in the suitcase. You called 911?
Yes.
Is it true that Detective or Deputy Kayla Rodriguez?
Oh, damn. Wait a minute. I object to first of all, the crack of noon. The crack of noon is when she woke up to check on George. It wasn't the morning. It was, she laid in bed from 11 to 12 to hear her say it. And then 12:15, she realized she'd not heard a peep from George. So, sir, stop trying to do revisionist history. It's not like Sarah Boone got up at 4:30, went on a jog, got her life together, cured cancer, figured out how to keep Guam from tipping, and then just happened to come across George at 7. Ew.
Rodriguez of the Sheriff's Department arrived.
Yes.
What mental state did you have at that time?
I was very confused. It was very hazy. I didn't understand the monumental amount of people.
Were you still in Schrodinger's drunkenness, not drunkenness? I can't drink, I don't drink, I blame it on the wine. I mean, where on the spectrum of, admitting your drunkosity were you, ma'am? How hazy was that for you? Ew. Yeah.
People that were there and what they were doing with taking things from my home. I was worried about my dogs. I was worried about my son. I was in shock.
Oh, your son. You mean what's his name that you forgot to, pick up most of the time? You mean what's his name that you also put in suitcase once and got CPS? Sure, Jan.
traumatized by the situation and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Objection, Judge, move to strike. This is outside the.
Huh. No, again, I remember you being Schrodinger's drunk. So now you've come to a conclusion. Is it like if you observe light and it can be both a particle and a wave, depending on how you observe it, but it can only be one or the other depending on, how one does the experiment. You can't observe it as both a wave and a particle at the same time, because I think that's a little too highbrow for you, Sarah, but okay. Yeah, pretty much. And then Raj Vortex, she mentioned her dogs before her son.
Had their motion to suppress. They have not made any allegations that her statement was involuntary because of her mental state or state of intoxication.
Response?
Judge, we're talking about, I'm just getting some preliminary information.
But
Her interrogation is the next day.
the state has an obligation in the
Wait, no, lawyer, you are making the exact point that you are trying to vilify the cops for. You are establishing a rapport, painting a mental picture, but you're not going to get to the relevant point at hand until 30 minutes later because you're dumb. But this is exactly what people do in interrogations. They establish rapport, they try to get the person relaxed, and then they go into the bulk of the interrogation, which is where they generally introduce the Miranda rights. It's almost like you are unmaking the point you are trying to make, sir.
and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and a surprise.
Okay, this is the
Are
day
you-
before the interrogation.
I understand that.
We're not talking about an intoxication.
But are you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what?
Thank you, Sarah Adams, for the super chat. And yeah, I love Sure Jan when I can't say, well, I'm trying not to curse as much when not provoked. So I'm trying to not curse, but Sure Jan is about the only way I can say that without cursing. Uh-oh, the judge is about to pull this trial over and only the state's getting a frosty.
what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol? Yes.
All right, I'm going to sustain the state's objection.
Relating to the intoxication?
Yes. It wasn't raised in any of the 3 motions that have been filed.
Judge, I didn't ask her that. She volunteered
I
that.
understand it. Objection sustained and it's stricken.
Welcome in the
Did you
garden.
speak to the deputy about what had happened?
Yes,
Okay. And then, were you asked to stay on scene?
by both, yes. By both detectives, yes.
Okay. How long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away. I don't know specifically, but it was not quickly.
Okay. Did the two detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
No foundation for her to conclude anything.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you explain what the detective?
Sarah, I even play for the other team and I was like, well, it's kind of like Henry Cavill. I think everyone can admit they're a little bit of a Cavill sexual. And I'm just saying, if detective with the good hair looked at me and was like, hey, I'd be like, well, I am very, very flattered, but I'm married.
Detectives told you as it relates to you getting in the car? What was the phone issue before the car?
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that Hopesall asked me was if I owned a phone.
And what did you tell her?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Sustained.
What was the next thing that you were told?
Also, okay, maybe I have my own petty bias against Sarah, but who do you think a jury's going to believe? Detective Great Hair, who says, I went in, I checked the scene before talking to Sarah, and I noticed a phone, or Sarah Boone? I told the detective where the phone was because I was trying to be a warrior for justice and Jesus and gin. Maybe more gin. To be fair, just strike all those other ones, just the gin.
Told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Hopesall.
How did you unlock it?
She handed it to me and I unlocked it.
How do you unlock your phone?
It was with a passcode.
Okay. And when you unlocked it, did you give it back to the detective?
I did.
All right. Did you ever see the phone again?
I did not.
Okay. After that incident, was the next time you were spoken to by Detective Copesall was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you?
Raj Vortex, I have no doubt that she will probably be called by the state as the primary investigator. And then I have no doubt that she'll probably be called over by the defense if they are able to get any of this suppressed. I would not put it past the defense to try to wiggle this in, and say, oh, well, you didn't read her, all of the things. I have a feeling the defense is going to be incredibly inappropriate and try to wiggle and finagle things in that they know will be objected to just to get it out there.
Tell you anything about what was going to take place once y'all got inside the vehicle?
Same.
That she was just going to be asking me general questions.
Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes.
All right.
Wait a minute. Is Sarah Boone, the arbiter of truth, now saying that standard protocol that lawyer Owens was going on like a buffoon about was not even said in her recollection? Are you currently drunk and hazy?
Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No.
Did they ever indicate to you that you were a person of interest?
No.
Did they ever refer to the videos that you recorded on your phone from the night before?
No, because they had not even gone through the phone. What kind of absolute ass backwards logic is this? Again, the fact that the cops let you go when they didn't have all the evidence to be able to charge you is showing that they are going by a standard operating procedure and are not trying to be sus. Ugh.
Were you ever questioned about those videos at the scene?
I was not.
All right, after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes.
Were you allowed to leave the scene at that point?
I was instructed by both to not.
Okay. And how long did you stay on the scene?
The entire time.
How long was that? How long did it take before the investigation was completed?
10 hours or more.
Okay. At some point, did they all leave?
Yes.
And at some point, did they tell you they were finished with the work there at the scene?
Yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right. And how far was that away?
About 5 minutes.
How did you get there?
I drove
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
This is also part of my deep-seated rage against Sarah. This family is not able to speak out. They have been on a gag order for the last 4 years. And yes, any human would be absolutely ticked off if they found out that their son was stuffed in a suitcase. Not only that, but then to have it emerge the absolutely cruel, callous, and demonic way you treated him. Yeah, absolutely. Absolutely. But you know what I can tell you as a person who lost a very, very close loved one, my first husband, you know what I can tell you? Only people like Sarah think of revenge first, because the only thing you are thinking when you first hear that news is my world has exploded. My world has exploded and you are trying to find any gravity. And I can tell you that I probably, even if I were presented with the exact same fact pattern as, George's family, my first thought would be, I've lost my child. I've lost my child that I birthed and brought into this world, that I nurtured, that I remember as a sweet little boy getting into the cookie jar and doing all shenanigans. What is my life going to be now? How is this fair? Sarah, I'm going to tell you this from the bottom of my heart as Sailor Mo. No one thinks that highly of you. Our worlds don't revolve around you. I know your world revolves around you, but I can guarantee you that that George's family was thinking about how they lost their brother, their son, their father. They weren't really too processing anything else because it destroys your world. It destroys your world. And it absolutely fine. Whatever, ma'am. You were afraid. I'm glad you ran away and you inflicted yourself on Brian. Ew. Just ew. And I am so sorry. I'm not buying it. Grief Club sucks donkey dick. Excuse my French. And no one wants to join it. And it's a suck club. And I'm sorry you had to join too.
Now, later that evening, You were going to spend the night there with your son and with your ex-husband?
Correct.
And did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact Detective Kopsel?
I did.
And whose phone did you use?
Former husband, Brian Boone.
You said your phone had been seized
Correct.
and you had consented to that? You signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Kopsel told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of the?
Sarah, let me explain this. That was before they had gone entirely through it and realized that you had incriminated. Yeah, I know. Are we trying to make this harder on her? That was the line that forever cemented Sarah as corroded trash dumpster water for me. She is lower than like a human garbage person. You know that water that collects in dumpsters and has all the weird creepy crawlies in it? Yep. That would be her.
Day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Kopsel's private cell number?
She gave it to me before she left the scene.
That was a
And
mistake.
did you call her?
I did.
Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
And that would have been on February the 24th of 2020?
Yes.
All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything or if I just wanted to talk to her about something regarding the case for me to call her. So I took that to heart and felt very uneasy about how they left the scene.
Sustained.
Go ahead.
There's no pending question at this time.
Okay, you were concerned about the case and you wanted to call her?
Yes.
And did you talk to her?
Yes.
What did you say to her?
I told her in all honesty that I felt that she was trying to trick me.
Yeah, what Sarah Boone thinks doesn't matter a hill of beans in law. There's not a Boone's Law Dictionary. There's a Black's Law Dictionary. It's just, he is this fake meekness. This is underlined by the furrowed brows, by the resting see you next Tuesday face, and the absolutely grossness that she is. And this isn't going to work. Again, when you have really dealt with abuse in your past or know someone that has, there are certain, again, you might not be able to verbalize it, but there are certain things and behaviors that one person can recognize in another. And she has none of those characteristics. She doesn't curl in on herself. She doesn't startle to loud noises. There are a lot of things, constant apologizing, constant, making yourself small, both personality wise, but also, in objections or things, it is very apparent when someone has gone through some ish and when someone has put people through ish, and she's not Meryl Streep. Although I do think she probably boiled
Sustained.
some bunnies in her background.
Did you have a conversation about your phone?
Yes. I asked her.
Overruled. You may answer the question, ma'am.
I know, I keep waiting for that.
Did y'all have a discussion about your phone?
Yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant and asked me if I remembered about when I was being pregnant. And it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
Was there any discussion about you being interrogated at the sheriff's department?
No,
Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
yes,
And the sole reason for the change in plans from them bringing the phone to you was because Detective Kopsel was pregnant and not feeling well?
correct.
Again, and Kaz, this is not live. This is yesterday. I have 3 kiddos who are now on fall break, so I had a lot of appointments to run, and one kiddo of those 3 that has caught the creeping crud that is going around the family. So this is from yesterday. Again, we are relying on Sarah Boone to be a reliable narrator. The hell? This did not happen. Again, Detective Kopsel was right on the stand and Sarah Boone heard exactly what happened. And even if Detective Kopsel had said, "I'm pregnant, could you please come down here? We need to talk about some things and your phone." If anyone's ever dealt with a person like Sarah, they don't hear what you're saying. They hear what they want to hear, and then they will make you feel like an idiot because whatever you have tried to bring up and you have clearly warned them about or talked to them about, they didn't hear it because they weren't paying attention. They only heard what they want. And she's going to have a really hard time selling this battered spouse self-defense by Samsonite cockamamie story.
So the next afternoon, did you drive to the sheriff's department?
I hope Brian
Tell
got his
us-
car back.
When you parked your car, where you went, what happened?
I parked my car and left everything as regular in my car and walked through the front door and
What about your notebook of questions where you were going to ask whether George's engagement ring would be returned to you? And I love this pause. This pause is terrible for her. I think I will screenshot it and make it a thumbnail. God bless pause and the internet.
went to the window asking who I needed to see, and they, I guess, rang them upstairs, and Detective Lowen came downstairs, and I thought I was supposed to be picking my phone up over at a particular window, and he says, "No, your phone is upstairs, so we would just like you to come upstairs, and that's where you can pick up your phone."
All right. And so did he escort you upstairs?
He did,
How did y'all get upstairs?
in an elevator.
And what was he wearing?
I believe he was wearing a red shirt along with his firearm and black pants
His firearm was on his waist?
the entire time, yes.
Okay. So y'all got off the elevator. Where did you go from there?
He brought me
She
into
remembered how she got upstairs this time?
And they had me sit down, and then from there I had a list of things that I was going to ask them that I might need to do or that I could do.
Okay. So from the elevator, Detective Lowen escorted you directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else prior to that time. Was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room?
No,
Okay. So directly off the elevator and walked into the interrogation room.
correct.
And then we've got the video on that. Now, you and I have watched the video, correct? And you've
was he
seen the
drinking
motion.
wine
Well, I've
together while
referred to
doing
the
it?
questioning where she asked you to sit down.
Yes,
You recall that happening.
yes,
Did that refresh your memory watching the video?
yes.
Well,
Do you recall her
boy.
saying that she had received the autopsy?
Yes,
Do you recall her saying, "I want to read you your rights again because we have to talk about that," referring to the autopsy?
yes,
This was prior to you being read your Miranda rights.
correct.
She also said, "We're not done talking about the incident."
Sarah, do you recall saying, tell me and we'll both know, when asked why George had a giant head wound and other abrasions and injuries all over his body? Do you remember that? Because you seem to be remembering a lot of things today. I'm just kind of trying to catch you on a non-hazy day.
You recall that?
Yes.
And then she said, we just have to do it.
Yes.
How did that make?
Oh my God. How many things was Sarah persuaded to do by the Just Do It Nike's commercial? She's like, Nike told me to do it, so I bought all the Air Jordans. I mean, what else can we get Sarah to do? Do you think we can get her to say tack it? Here's hoping.
How did that make you feel?
Sustained.
Were you trying to comply with the officer's demands?
Overruled.
In every way.
Were you trying to cooperate?
In every way.
Were you polite with
Ew.
them?
Very.
And when she said that, we just have to do it, you said, just like we did yesterday.
Yes.
And then you said normal protocol.
Yes.
Is that what she had said the day before?
What do you mean?
Normal protocol.
Yes.
Had she?
No, Sarah, remember just 20 minutes ago when you said that you didn't recall that normal protocol or any phraseology of the sort was used in the unmarked car. I'm going to need you to remember the transcript of what you've already testified to just 20 minutes ago. If you're going to be a liar, you have to remember these things.
Had she said the same word? You said normal protocol to her.
I was reiterating to her what she had said to me the day before.
So she read the Miranda rights to you,
Except number 9.
except number 9. She read the rights and then she said,
Sarah Boone, did you know about number 9? The answer is no.
do you understand what I've just read to you? And you agreed that you had,
Yes.
but you were not
Welcome,
read
Husky Apple.
having these rights in mind. Do you agree to speak to me now?
Overruled.
I was not asked that question.
Is it fair to say that after she read the Miranda rights and after she said, do you understand the rights that I've just read to you, that she read right into the questioning?
She did, correct.
So she never got the answer from you. Do you agree to speak to us now?
I was never asked that.
Come on, Owens, this is your moment. This is your Matlock moment. You can't handle the truth. Only it's your own client, so it might look a little bad. Come on, Happy Gilmore, what the
The
hell are
way
you
that
doing over
she
there?
acted, the things that she said, the fact that they had your phone. Did you get the impression you were not getting your phone back if you didn't answer the questions?
Sustained.
She was in custody.
Thank you so much, Raj, and have a
That's been
great day.
conceded by the state in their response that it was a custodial interrogation.
But she wasn't.
Did we just become best friends? Sarah's present tense opinions or impressions matter in no way, shape, or form. She is not an expert. And the state said in their motions, which you should have read, Owens, that she was in custodial care at that point. But continue to make your useful as tits on a bowl arguments. I enjoy it. The brain slug has rendered me just dumb enough to not care.
She wasn't aware of it. She wasn't aware she was in custody.
What does her subjective perception matter?
Well,
Preach.
under the circumstances, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed small space. She was.
That all goes to
she was
whether or
being
not.
questioned. She She was being questioned by two lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think
So your defense is that your defendant is a moron and is dumb and can't understand and put together context clues? That seems like a her problem, not a legal justice problem. Yeah, phraseology. And yes, he just shushed the judge. The judge better put a rein on that real quick, because that is the one thing that I wish he's done pretty well, but I think that Owens is only going to get worse with a jury in there. And regardless of optically, Owens and Sarah don't understand how terrible this looks from an outside perspective. So this is going to immediately turn off the jury. But yeah, he's going to continue to do this, and he's going to do it even more showboaty in the trial. So the judge needs to nip it real quick.
her position is that she was coerced into answering the question.
What does that have to do with coercion? Those are all factors that under Ramirez as to whether or not it was custodial.
Well, I know some of the factors are whether or not the interrogation actually happens in a police station or not, or whether it happens outside a police station. So just that environment alone.
That goes to whether or not it was a custodial interrogation. I'm struggling with the connection on that being noncompliance with Miranda, coercion, or the third ground of voluntariness.
Well, and I think it goes subjectively to her and what she was feeling, if she had a free choice or not, based on
subjectivity matter.
Excuse me, based on
subjectivity matter under the case law.
It's the basis of my whole
based on the
case.
circumstances that she was dealing with at the time, whether or not she felt she had a choice.
But what does her subjectivity have to do with that?
Yeah. What, Sarah had a Sophie's choice about whether going into the... No, none of this. No. Sarah Boone feeling any sort of way does not ameliorate any of this. But good try, Owens.
I believe it's relevant.
Objection's overruled. I'm sorry, the objection sustained. I apologize.
Did you understand you were not going to get your phone back until you answered their questions?
Sustained.
Did you have some questions for them at the end?
I did.
Did you feel like you had a choice in answering their questions?
Sustained.
You just try to ask that question. They're going to object to it every time.
Man, that day, you came to the sheriff's department to get your phone?
Yes.
Asked and answered.
Did you know that you were going to be placed in custody?
I did not.
Did you know that you were going to be arrested?
I did not.
Did you know that you were going to be questioned?
I did not.
Were you trying to cooperate with law enforcement based on her statements that you have to talk to us?
Yes.
Overruled.
Were you there answering the questions because she confirmed that this was normal
Welcome,
protocol?
Stacia.
That was my understanding, yes.
That's all the questions I have.
Any cross-examination?
Come on, state. Let's drop it like it's hot.
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
You were impaired by alcohol, correct?
I don't know as much as impaired means. It did affect, yes.
Okay.
Oh,
And
no. Say it the way she will understand it. Were you compus mentis? I would go in and I would do, look, y'all, the petty would not end with me. I'd go up there and say, Miss Boone, were you compus mentis, when you were on the crime scene? And she would say, I was not, but I don't understand what that means.
And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct? You consumed no alcohol in your home that morning, correct? So does that affect in any way your memory when you testify about the events that transpired between you and Detective Copesel that afternoon?
Ask one more time, please.
Did the alcohol have any effect on your memory of what happened between you and Detective Copesel that afternoon?
Now or then?
Then.
Did alcohol affect?
Both. The answer is both, because you obviously did not remember the situation in any sort of contextual way, but you can't have it both ways, Sarah. You can't be so drunk that you weren't able to answer questions and the officer should have known that you were a functional alcoholic, but also, you know, you are in your right mind and you knew something was wrong about this. Just can't.
Affect my conversation with her?
There's a jury instruction that says a witness's memory and perception is pertinent. And I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect my answer?
Judge, I don't think she understands the question.
I don't.
Okay.
It's been asked 3 different ways.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she doesn't know.
Are you under the influence of alcohol right now? Stevie Wonder could understand. I mean, Stevie Wonder could see what he's trying to ask. Also, are you playing the Theodore Edgecombe thing now? Where can you repeat the question? Because I think that Judge, Browse of Justice is not going to. He's going to go full Borowski on you. Have fun with that.
You know what? She said that she had alcohol under the influence or impaired.
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
It makes her look bad, and she's my princess.
I know that she had said she didn't know what it
What are the legal grounds of your objection?
I'll withdraw.
All right, you may proceed.
And you understand that you're charged with second-degree murder in this case, correct? You're facing a potential penalty of life in prison, correct? Do you understand that the score sheet minimum is probably about 22 and a half years?
Oh my God, preach.
Okay. And it is your desire to have these statements excluded from the jury's consideration, correct?
Judge, I would object to that.
Sustain the objection.
Your intent is to testify differently than you have testified in the statements in State's Exhibit 1, correct?
I would object to that. I'm not understanding the question.
Mr. J.
Judge,
Neither of you
a
can
witness's
understand.
bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Copesel's testimony, and the court, of course, in a motion to suppress has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination,
I'm not reading that one out,
that
but
both state
yes.
attorneys and defense counsel and the state's expert witness today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is biased in all the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out so that she is not going to be crossing.
Sarah, you can't hide that smirk under confusion. I know you have your angry eyebrows going down like, I is really confused, but then you're doing this full on, suppressed Karen face. But, I understand that your face doesn't move that much. So I guess I'm hoping that the state's attorney doesn't have a bunny is all I'm saying, because yikes, that she is like imagining the last 3 minutes of Old Yeller right now, trying to look sympathetic.
Cross-examined and impeached with it so that she can testify the way that she testified this afternoon.
response.
Judge, I agree with the impeachment about being under the influence. I agree with the impeachment about what she's facing. That she may be
I will
biased,
work on that.
she's
I am
facing
working on merch. I'm just dead awful
years on the low end.
at most computer
With
things.
all that, we just got through at the jail, meeting with the state's expert who evaluated Sarah Boone. I was present. The two prosecutors were present. It wasn't recorded. He can't be a witness now. If he's going to question her about what was said during that evaluation, and he's putting himself potentially to be a witness down the road, I don't think that's proper cross-examination about what she said there versus what she's saying here.
Anything further? Mr. J.
I am not specifically asking her what she said that was different. And obviously, if I did and she testified differently, I would have to accept that answer. There's no way for me to extrinsically impeach her with that due to the brevity of the time frame that we have all been subjected to. But I
It's
do
a good
believe it's a
question,
fair
Reindeer.
question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
Oh, I love you, Bronze of Justice.
Statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020?
Yes.
And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I,
And so you understand the benefit of this motion to suppress being granted.
of course.
No other questions?
Any redirect examination? Okay. We can have Ms. Boone return back to counsel's table. While she's in the process of returning to counsel's table, anything else further from an evidence or testimony perspective from your side of the ledger? Okay. Anything else from the state other than argument?
Just argument.
Okay. All right. Once Ms. Boone's seated, we could proceed with any argument. And as the court identified previously, I have reviewed all y'all's authorities that were provided. Mr. Owens, it's your motion, sir. You may proceed.
You have a time limit of 15 minutes, and I don't want to hear crying. Oh, God, how many papers? Okay, no, this is why I couldn't deal with stuff at school, because I am too type A to function, but I also have ADHD. So people not being prepared bothers the ever living snot out of me. So he had time while Sarah was giving her non-answers to get all of this prepared to go up to the lectern and not look like an absolute moron. But no, he's going to continue to waste my time. Oh, he's getting to the part where Sarah wrote him
It's
what
my
to say.
understanding of the law regarding Miranda. First issue is, was the defendant in custody, was the suspect in custody? Was it a custodial interrogation? We have agreed or stipulated to that fact. We're referring to the 2-hour interrogation at the Orange County Sheriff's Department. Specifically, we're referring to about the first minute or two of that video. And I think under the totality of the circumstances, the court has to determine whether freely and voluntarily and knowingly given under the circumstances. Judge, law enforcement, after they get a valid waiver of rights, that I'm not going to be silent, that I'm going to answer questions, go ahead, ask me and I'll answer the questions. Once that happens, law enforcement is trying to get a confession. Law enforcement is trying to get admissions that they can later use at trial to impeach the defendant and convict him.
Oh my God, who listened to
The
courthouse?
law allows law enforcement at that stage to use deception, to lie, to trick. We found the murder weapon. It's got your DNA on it.
Wait,
Your
this is becoming dumber and
co-defendant has
dumber.
come
I
in
think
here
my
and
brain
confessed
plug
and
is not
implicated
working.
you. All those techniques, when it's really deception, they don't have the DNA, they don't have the murder weapon, they don't have the co-defendant, can be utilized to obtain a confession or an admission of guilt. But prior to Miranda, you cannot deceive. Prior to Miranda, you cannot trick. That right is fundamental. You cannot be compelled to incriminate yourself. You cannot be forced to talk. It's got to be free will and a choice. And so you can't seduce or coerce someone into giving a statement. And the law is clear when that happens.
Okay, beyond Brian, and I don't know why, but beyond Brian, no one has ever in their life tried to seduce Sarah Boone. Ew. Nope. Detective Great Hair is like, oh hell no, I did not try to seduce her. And guy in the red sweater or the red shirt is like, oh hell no, I was wearing my shiny shirt for my wife. She's the only one that gets all this and my sidearm. If you know what I'm saying.
Happens, we've got to punish law enforcement to correct that type of misuse behavior. It's illegal. So you got Detective Kopsel on the one hand. I got to read your rights.
Reindeer,
You have a
I
right
don't
to
think
remain
so.
silent. But within a minute before, the detective is telling Sarah Boone, we have to do this. We have to talk to you. Now, that's confusing. That's deceptive. There's nowhere in policy that should be allowed or is allowed. There's nowhere in the law that should be allowed. It's actually illegal.
Same.
To tell a suspect, we have to talk to you. We just
Jung, they did read her rights. It seems that Detective Greathair was operating on a Miranda card that was from 2013 that doesn't have the 9th question that states, and this is probably not verbatim, but having been warned of all these rights, are you willing to talk to me? But they did in fact read all of the Miranda warnings that they are constitutionally bound to. They simply didn't, ask her this, having heard all of these, are you willing to talk to me? But Sarah indicated that she was willing to talk to them by starting to run off at the mouth absolutely the second after she stopped talking.
have to before reading Miranda rights. That is an illegal statement. Sarah Boone did not have to talk to them about the autopsy. Sarah Boone did not have to talk further about what had happened. But that's the implication this detective gave Sarah Boone. It taints the Miranda that comes before it. Here's a law enforcement officer. I'm trying to cooperate. We've got to talk to you, but you have a right to remain silent.
Oh, if only Sarah had gotten one of those lawyer
The
people.
statement of we have to read you the rights was made before we have to talk to you. So your argument transposes those two things chronologically.
Why are we even having it? I mean, why even have the confusion? I mean, we're sitting here Monday morning quarterbacking, but Sarah Boone was brought up there under false pretenses. a traumatic event. She lost her boyfriend.
Well, she lost.
I'm coming to
and
get my
found him.
phone. I've been tricked into coming up here to get my phone.
Oh my God.
And I'm sitting here having to figure out what to do about whether to talk to these people or not. And she's talking about my rights, but then saying, we have to talk to you. We just need to do it. And then she reads the rights. Right there within a few seconds of each other. That's improper. It's illegal. It's coercive.
By this logic, I get to sue Mike and Ike's because they were right next to me, and the movie boxes are only like $1. So when I went to Walmart and let's say for the last maybe 6 months of this past 3 years, I was gaining and retaining Mike and Ike's, and wait, it really is Mike and Ike's fault. That's it. I'm starting a class action lawsuit. Anyone else want to join me? Mike and Ike's will pay for my bigger booty for a little bit. What the hell? This is dumb as hell.
It forces this not to be a valid waiver of her rights under that circumstance, coupled with the fact that she came down under false pretenses. Coupled with the fact she doesn't have the 9th question.
Not the 9th question. No.
If you think about it, okay, you got a right to remain silent. You got a right.
Hey, Sarah, you only broke one of the 10 commandments that we know about. So really, what Owens is saying, by that logic, the fact that she just, broke one of the commandments, kind of the big one, you would think that would kind of be an issue, but okay, by that logic, still heaven for you, because only one. Thank you for your support, Jung. I will try to remember. I make no promises that it is BTS and not BTK. I will try.
You got a right to a lawyer. Those 3 or 4 questions, and then, do you understand what I've just read to you? I'm paraphrasing. But then Detective Kopsel goes right into questioning. Once Sarah says, yes, I understand, it's an acquiesce to authority. Okay, let me start asking her questions. The critical question is, having these rights in mind, do you agree to speak with us? That is the time of free choice. That is the time of decision for Sarah.
What, like it's her bar
to be given
mitzvah?
that opportunity. But the way...
Like she's in catechism, right? Getting ready to, rededicate herself to Christ, and what? The time of choosing? This is not the Hunger Games. Get over yourself, Sarah. For the love of all that is Cheetos.
I understand. Detective Kopsel had the autopsy. She had the blunt force trauma.
She had the snuff film.
Those were not questioned. Sarah Boone was not questioned about that. They didn't know about that until the medical examiner. So she had additional information that she wanted from Sarah Boone. She had the 2 videos from Sarah Boone's phone. She had additional information from the phone that was inconsistent with the statement that Sarah had given the day before. So sure, any detective worth their salt would want a statement. She'd already said we had probable cause. We'd already made our mind up that we were going to arrest her. If she didn't come, they were going to go get her. If she came and said, I want to invoke my rights, she was going to be arrested. They wanted to get some type of admission, confession, statement that they could later use, which they're trying to do now. But under the circumstances, the totality of the circumstances about how she was induced to come down there, about telling...
So these were several motions, and I did read through these motions, but basically on the video portion of the motion to squash, he claimed that she didn't relinquish her phone voluntarily. Basically, like they stole it. Detective Great Hair like ran and bum rushed her while she was pregnant and took the phone. Now it comes out that she signed a waiver and willingly gave her phone to the detectives, as we all kind of knew. But they also claimed that because she was not asked this very important ninth question, that the entire interrogation should be thrown out. So that's kind of where we are. That's what they're arguing. It's both dumb and stupid at the same time, to a level to which I didn't think Sarah could stoop to. But apparently, when she can puppet her own lawyer, this was the argument that 9 other lawyers said, nah, goodbye. Bye, Felicia. That's basically what they said as they left.
Telling them she had to talk, Judge, it was coercive. We would ask that you suppress the evidence.
Any response?
Everything he just said was so moronic, I don't deem it with a response,
Judge, the
Your
United
Honor.
States Supreme Court has said that confessions are good. They are good for society. It is good when guilty people are convicted. We stand by all the case law that we've cited, and you have reviewed the evidence from start to finish. Under the totality of the circumstances of that 2-hour and 6-minute statement that she gave to law enforcement, she knowingly and intelligently and voluntarily waived her Miranda rights. And under the case law, it was done perfectly fine. There is no requirement that that question number 9 get read. And as far as any credibility issues that are pertinent to the court's analysis, which the state would submit there is not, because we are conceding there was custody on February 25th. They are allowed to use subterfuge and deception to get somebody to come to the police station under the case law and authority cited. But if there is anything that is dependent upon the credibility of either the defendant's testimony or Detective Kopsel's testimony, the state would argue for the reasons of her being impaired by her own admission on the afternoon of February 24th, still from the night before, that her credibility is less than Detective Kopsel's. And of course, she has a bias and interest in the outcome of the case, whereas Detective Kopsel has no motivation to not tell the truth about whether she used deception to bring the defendant down to the police station, because that's perfectly acceptable. So we're asking you for the reasons that we stated in our multiple responses to.
You guys, I know it is super petty, but I am going to Walmart. I will be buying them out of Diet Dr. Pepper, and I will be obnoxiously drinking a Diet Dr. Pepper throughout this entire trial. Sarah, just for you.
To their multiple amended motions to deny their motion to suppress. Thank you.
Any further argument, Mr. Owens?
No, Judge.
All right. Tomorrow is a court holiday. The court has had the opportunity to review all the case law. Court's going to prepare a written order, and you'll have it before the close of business tomorrow. Courthouse may be closed, but I'll be here working.
Judge, and for the record, those 2 exhibits that I tried to introduce, they will be admitted
Correct.
into the record.
Yes, of course. They were pre-marked. Moving now to the defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial. State, what, if any, positions do you have with regard to the restraints?
Again, we've already decided that issue. I don't know that there's been any new allegations alleged in the motions by Mr. Owens on behalf of the defendant, but the court has decided that already. And unless there was some sort of change in position or authority, then the court should maintain the law of the case.
Response.
Judge, I just want clarification, but she's here today and she's in handcuffs, so she has difficulty writing.
Let me just interject for 1 second. She will be hands-free.
Okay.
So the issue is the leg restraints.
And Judge, she's presumed innocent. I understand security has an obligation. There's 3 doors. I assume we're going to be trying the case in this
Yes, sir.
courtroom. There's 3 doors. I know that we've got several security officers here in case she were to try to flee. But she's got no access to weapons or anything of that nature. She has a fundamental right to a fair trial. She has the fundamental right to a presumption of innocence. And if the jury were to see any restraints on her freedom, they're going to automatically assume the worst, that she is a danger. And people automatically will take that.
Honey, even before they see the handcuffs, they're going to see her face and realize they wouldn't want to run into her in a cold DMV. So, I'm pretty sure that I'm going to be real honest with you, sir. I don't think the handcuffs are going to be the biggest prejudice. I think her face and her talking and her face are going to be the first things they notice. But okay.
Take that to heart, and it will affect their decision when they go back into the jury room. So, yeah, she's going to be at the table. I don't know if we switch it. Does the prosecutor go over here?
No, that's your table, sir.
That's my table, closest to the jury. So she'll be sitting here with the other two lawyers and I. And the only time they're going to see her walk in and out is she's always going to be in the courtroom.
They're never going to
first.
see her walk in and out.
Yeah,
So
they never will.
The only time is when she testifies. So I guess I don't.
Owens, it's called, have you ever seen any other trial before? Generally, what they do is they will excuse the jury, take the defendant to the juror box, and then invite the jury back in. While it is fairly, people can definitely logic out why they would do that if they were on the jury. No court I have ever seen has, marched them, frog walk style up, fully shackled, and then have them testify that way. I'm guessing that's what they're threatening us with a good time.
I don't know if you have leg restraints that she can wear and walk, but we believe
Yes.
it's not necessary. And of course, we definitely don't want them to see her walking funny or hear something funny or see something funny. And she's walking from the defense table to the witness stand to testify on her own behalf.
You're not going to see that.
But I don't
He's
think
already
it's
said that.
necessary to have leg restraints. I think once she gets in here in the trial, beginning Monday, jury selection, and I assume the tables are going to stay here.
The privacy panels will be located in front as well, which will prohibit our jury from being able to see any of the leg restraints that she has.
I don't think it's necessary to have the leg restraints, Judge. I think you can bring her in with the leg restraints, but take them off right before we get started. I don't see a problem with that. I
What
don't
is up
think
with
she's
this
a threat.
defense and
You know, there are
feelings?
times when criminal defendants are in a trial and they misbehave in the middle of the trial, so they have to be restrained. But Sarah Boone, as far as I've been involved, and I think prior to that time, has always been polite and cooperative, and she understands the importance of behaving, and I have every intent that she will comply.
Owens, are you wearing rubber-soled shoes right now? Are you wearing rubber-soled shoes? Because look, I am irreverent as hell, and I make sure to wear Crocs when I'm going to say something that bold-faced lie. So I hope you are wearing Crocs with that, because I don't know if you're going to be able to avoid the lightning strike for that big a lie. oh, you made me laugh.
Comply with the court's directive, and she will act appropriately throughout the trial. I do not believe any restraints are necessary during this trial.
Anything further as to that issue?
I don't believe that's case law authority on the issue. I believe.
All right, thank you very much. With regard to your request for clothing in that, you could certainly go to the jail and have whoever it is that you want to meet with her in the meeting area to get measurements from her and provide clothing. The clothing for trial will have to be provided to her at the Orange County Jail. That will be brought over with her in the morning, and then she'll be able to be dressed out downstairs. So your motion will be granted with regard to the clothing. You'll have to address with the jail, having a person come in there to take her measurements. They may have to be with you, counselor, in order to facilitate that. But the clothing will have to be dropped off at the jail, and it will be transported with her in the morning each day of trial. With regard to the appearance issue, do you have any other further argument as to that?
Judge, just what's stated in the, I made some legal arguments in the defendant's motion for the right to hair, cosmetics, civilian clothing without restraints for trial. Just the arguments in there.
And the Estelle case that you spoke to being dressed out in a prison garb. Doesn't really address a prison guard in shackles. It doesn't address any beautification or anything along those lines.
I just think it's you know, it's just part of a fair trial.
The other problem,
Look, I just want my girlfriend to look pretty full. I mean, you know what? Just go with that argument. Let's be, at this point, you've used nothing in the Constitution requires, Mary Kay products to be delivered to you. But okay, sure. I'm sure that'll be the next human rights issue that we will be fighting over.
problem is it's contraband. That stuff's not even purchasable at the commissary at the jail, any makeup or anything along those lines.
Well, I'm going to have the two paralegals here. I say the paralegals. One's a lawyer now, and the other is a consultant. But they're females, and they can bring the cosmetics in and apply it either here in the courtroom or just outside the courtroom. I'm sure there's a waiting room. There's no place where we can apply any.
You can't put them back there because we can't allow access back there. That's for corrections and for the sheriff's department and for the inmates.
Can she be
Also,
allowed?
way to volunteer your underlings to have to put cosmetics on Sarah's face. I'm ready for my close-up, Mr. DeVille. I mean, of all the scarier things that I'd have to put poor refiner on, Sarah Boone would be the scariest. Also, how is it that you didn't know one of your paralegals made it to become a lawyer? You're gross, Sarah. Again, pay attention and acknowledge the accomplishments of women. And I hate having to say that because usually I'm not for the whole, acknowledge women, but you seem to really dislike or discount women's achievements, which is odd because you're representing Sarah Boone, who has no achievements. Well, it kind of makes sense.
Allowed? Can the two females on the team, can they be allowed to apply some type of makeup to Ms. Boone?
State?
We don't have any dog in this fight. I've never heard of it happening. That doesn't mean it's not permissible, but.
If you want to try to do it here in the courtroom, that's fine. But be advised that, when we start court, we start court. So, and I intend on starting it at 9:00 every morning. So I'll have pleas every morning in other matters because the court still has other business at 8:45. And I plan on bringing the jury up at 9 until we select one and then starting at 9 every day thereafter. So your motion will be granted with regard to the clothing. You can perhaps someone attend, travel to the jail with you, sir, Mr. Owens, to take the measurements. You'll have to provide clothing at the jail. With regard to the appearance, it's denied to have anything happen at the jail or happen in any of the secured areas. But if you want to attempt to have members of your staff apply makeup prior to trial, you certainly can do so. Court will provide you a written order with regard to the request for removal of the leg restraints. But the hand restraints will be removed. I think that it falls under the same analysis.
It needs to be done in the courtroom.
Yes, sir. And then the last item teed up for today is I'm sorry. Yes. Yes.
The sheriff is like, hell no, we are not going to let them play Mary Kay up here. No, not going to happen.
So corrections in the Orange County Sheriff's Office have just advised me that the concern is if makeup is affixed and then she's taken back downstairs and then taken back to the Orange County Jail, they don't know if it's contraband. They don't know what's placed on her person. And that's the concern.
There's just going to be some facial makeup.
I understand, but
I don't see.
DOC and Sheriff's Office are telling me they can't do it.
It's called no. You were told no, and that's just what it is. Sometimes you win, sometimes you lose. It swings and roundabouts, all right? So this is a loss. Sarah will have no help from, God and Spackle to look better. Because that would need a lot of primer. I don't know.
Because of the concerns that were just outlined. After she's returned to the Orange County Jail facility.
Okay.
All right. You'll get an order with regard to the restraints no later than tomorrow. Moving.
Sarah is going to lose her shit on him when they get back. I told you to fight harder for my makeup. How dare you? You're so lucky I don't have a suitcase here.
Now, the state's request for protective order, I've reviewed that.
I
I
am
need more,
so Jedi Jess, I will be covering the mornings, and then Squid will be taking the afternoons. As long as she is up and able to do that with her current setup. So I was going to be doing the mornings because you guys know I have 6 kiddos and I'm the mom taxi. So in the middle of the afternoon I always have to leave to pick up the kiddos. So that's how we figured we would split it. But I can always hop on with Baker in the afternoon sometimes and do that because it also helps me get some time to work on nightly newsy news. Yeah. Look, I'm gonna let you in on a secret, greedy bloke. Women put on makeup for other women, except for me. I will say, look, I have eyebrows, but they're blonde, so I have to darken them up. So I'm afraid that we have to be able to put on our eyebrows. I would agree because there's a whole lot I don't get about, contouring and if my winged eyeliner could ever look like vaguely close sisters rather than distant and not related cousins, I would be happy. But yeah.
I need to understand what you're looking at, Mr. Owens, with regard to these custodians and supervisors at the state attorney's office.
I did not realize that was going to be addressed today.
Yes, my JA had emailed all y'all, I think last week after it was filed, that said this would be added to the hearing for, I guess that was filed on Monday, forgive me. I had emailed y'all and said that it would be addressed today.
A dog ate my homework, Your Honor.
Continuing the enlisting the I think it was
It's the third amended witness list lists certain people as witnesses: custodian of records, Orange County Office of State Attorney, domestic violence supervisor for the Office of the State Attorney, victim advocate supervisor.
It is a
for the
really
Office
weird
of the State
thing.
Attorney, and misdemeanor supervisor for the Office of the State Attorney. And the state is seeking a protective order on the grounds that it's
Oh, I
work
know.
product or opinion product, and requiring prosecutors to disclose work product and impede criminal prosecutions is violative of Florida law.
Judge, as you know, we have filed our notice of intent for battered spouse syndrome in conjunction with
We know we can't
self-defense.
believe it.
And we have listed and plan to introduce the fact that George Torres had been arrested, I think 3 or 4 times prior to this event. And I think on 3 of those cases, the case was dismissed against Mr. Torres. And it's going to come out that Sarah Boone had requested the charges be dismissed. And I believe it's going to come out probably through expert testimony that that's one of the conditions, or that's one of the things that they try to do, bond you out of bail and then get the charges dismissed as a battered spouse. That's a common theme. So ultimately, the jury is going to hear about that, but the jury needs to know it's the ultimate position. The victim doesn't have the final say. It's the ultimate position from the state attorney's office as to whether to prosecute a case or to drop a case. Yes, they are to consider what the victim wants, and they are to consider their request, but ultimately, the state attorney has to make that decision about whether a case is dismissed.
What are you going to be asking from these persons?
That.
How would that not be protected by work product?
Well,
to whether or not it was a
if it comes out that she went down there and requested the charges be dropped and they were dropped.
How are you making this argument? Make it make sense to me, because you are saying on one level that while Sarah Boone's wishes would be taken into consideration, the state's attorney has ultimate discretion. So Sarah Boone going in there and saying jack diddly crap, it really, oh my God. Why? Oh, Lord. Yes, JKD Buck, I am on Rumble. I forgot to put this on Rumble. This is not going to get him anywhere. Again, the ins and outs of why the cases were dismissed, it's going to look really, really fugly when they play those. Well, they can't play the body cam footage of, Sarah's body cam with the domestics, but it's this is a weird hill to die on. This is a weird hill to die on, and it's not going to help your client.
Then that gives the impression that she had the power and authority just to come down to the state attorney and ask the charge to be dropped, and they would. When in fact, the ultimate call is the state attorney's office. They don't have to drop cases, even if a victim claims they do. So just that decision by the state attorney to drop it was their decision. They considered the victims, but it was their decision to drop it and their power and authority to do so, not the victim's authority.
Okay. Response?
This is the dumbest argument I've ever heard.
Judge, that's opinion work product. That is absolutely protected. I don't understand why he believes that arrests and dismissals are relevant. What is relevant in a self-defense case is if the defendant is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from anybody, and it does not matter whether the defendant's aware of it. The notion that this sort of evidence would be admissible, much less through the vessel of sworn prosecutors, and they have now gone ahead and named people who aren't even involved with the cases. Matthew Storch, Christina Mills, and Aaron McCullough, our head victim advocate, have all now, I learned while we were at the jail this afternoon, been served with subpoenas by the defense, and we are moving to quash those. Prosecutors and victim advocates and other support staff cannot be forced to come in and say why they dropped a case. That is opinion work product. And if they want to get public records about these cases and try to get them moved into evidence, then they have to do public records requests or compel discovery from the state attorney's office, which I believe we all have.
Thank you, pretend judge.
The state has just been dropped with her medical records that Investigator Lane got in 2021, even though they keep on saying in their amended discovery exhibits that they don't even have this evidence. We got dropped last Friday, the Aspire records and the Advent Health records that have documentation that Billy Lane picked them up in 2021. So the defendants had these things that are getting dropped on the state for years, and we're just getting dropped on us this Friday.
Wait, Sarah trying to hide discovery in a reverse Brady sort of thing? This seems apropos.
And now we are having to combat subpoenas and requests for documents.
Reindeer, she could, but I think with the battered spouse thing,
didn't handle those cases or make those decisions, but that is the ultimate protection, is why we drop these cases. And it's up to the defendant if she wants to come in and say, yeah, I asked to get these cases dropped. I mean, that evidence is coming in anyways through her phone extraction. She is immediately working to bail the victim out. She's immediately working on dropping charges. In fact, there's a video of her coaching the victim on how to drop charges against her on her phone.
oh my
So
God,
all that
this woman
evidence is
didn't.
going to come in, but it cannot be coming in through opinion work product of the assistant state attorneys and our support staff.
Any further argument?
I didn't make the argument. I did not make the argument that the state attorney was going to be called to ask why they dropped it, as he just referred to, where they had to explain why the case was dismissed. No, the reason for that is just to explain that they have the ultimate power to dismiss, not the victim in a case. Not why we chose to drop 3 cases against George Torres, but they have the ultimate authority. The victim does not control the case, the state attorney does.
You'll have a written order on the motion, protective order for tomorrow, by tomorrow as well. Anything else, state, we need to address?
It appears, and again, been conducting motions all afternoon, it appears that we are set to
No,
allow
I
the
don't think
defense
so.
to depose our battered spouse syndrome expert at 10 a.m. tomorrow.
Yeah.
And that will be done virtually.
With regard to the deposition of Dr. Brannon, the deadline is tomorrow.
That's set at 3 p.m.
Okay, that's still set at 3 p.m.
Yes, there will likely be a pending motion to strike if his testimony is duplicative Dr. Harper's. My understanding from the defense is he's just going to explain what battered spouse syndrome is. It's unclear why or how that would be different than Dr. Harper explaining that.
Is that taking place here or is that taking place in
Oh.
South Florida, virtually?
Unfortunately, due to time constraints, I cannot be everywhere at all times.
All right.
Judge, and then on Dr. Brannon's deposition, yes, it's set for 3. I'm just learning now that the expert is going to be available at 10, Paul's expert, or by Zoom. And we did talk about that at the jail, trying to schedule something for tomorrow. So she just evaluated Sarah Boone from noon to 2, and then I'm going to take her deposition at 10 tomorrow morning by Zoom.
Yeah, this is not going to go the way Sarah thinks it's going to go in her
File some type of
mental
motion about that.
canon.
I'm going to respond. We're going to need to have a hearing on it. So,
If you go ahead, I'm sorry.
but those 2 things are the only 2 things that I believe we have left prior to jury selection on Monday.
Okay. If any motions are filed by anyone moving forward, please favor a copy to my judicial assistant upon filing. And if there's any authority that you intend on arguing that's not cited in the motion, please provide me that authority as well. Although it is a court holiday, the court will be working tomorrow. I will endeavor to get you written orders on all of these things no later than the close of business, hopefully earlier than that by tomorrow. On Monday morning, State, if you could please bring a copy of the score sheet so that when I colloquy Ms. Boone prior to trial about the charge, the potential penalties, everybody's on the same page as to what those are. Okay?
Yes.
And if y'all could send me that, I'll go out to the jail. I'm going to be here.
If you could favor him a copy of that tomorrow or Friday so that he has the opportunity to review that score sheet with Ms. Boone in advance.
Yes. We're going to be filing a motion
Every
to
day.
exclude the battered spouse syndrome testimony that will need to be addressed. Just waiting to see now how the depositions pan out tomorrow. But based on what we witnessed this afternoon, it's the state's position that we're going to need to file a motion to eliminate.
Okay. All right. Appreciate it. All right. Thank you all very much. We'll address scheduling of any motions on Monday. And it may be a circumstance where, as the court had identified
Howdy,
earlier,
what's up?
that we're just going to be looking at cause issues and what people may know about this case. That'll be happening before we turn it over to you all, which would include, Mr. Owens, your opportunity to voir dire on any defenses that may be being raised in this case. So it may be, we may get a panel and then ask them to come back later in the week so that we can have those motions after we get that panel of 50, once we deal with all the cost challenges. Okay? All right. Thank you all very much. We'll see you Monday morning at 9 a.m. Court's in recess. Thank you.
All right, guys. Well, that is it for this hearing of, well, I can only imagine monumental WTFness. Sarah is going to be super pissed that she's not getting makeup because you know that she really, really wanted that makeup. Elizabeth Arden, she was going to go all glam-tastic. She's one of those chicks that, and I'm, look, when I was a starving college student, I'm not saying I did this, but I did this. You know, you go to Von Maur and you say, well, I'm thinking of a date look and I'm looking for some expensive makeup to really invest in. And then you get them to do your entire face, which you kind of rethink because you realize that the woman doing your makeup looks like Tammy Faye Baker, but it's still free makeup. So, you know, always good. Well, guys, I'm going to let you go. I get to run to the DMV because, you know, new driver, new fun. And let's hope that we get those orders fairly soon, and I will go over those. I am not going to be having nightly newsy news tonight. I promised the 2 youngest, most feral, that we would try to go to an apple orchard. And since I have my brand new spankin' walker, that is a tactical walker, it's supposed to go outside. I will be resting up for that. And JKD Buck, I will say that my local DMV has the nicest people. So that's always helpful when you have to go there against your will because it's outside of your house. But please have fun with this. If you guys would like to continue your Sarah Boone experience with Mo, don't hesitate. In fact, run to go look up Legal Shenanigans Theater. It's on my channel. Veilhammer helped me with the background, but it is a wonderful marriage of Mystery Science Theater and two people making fun of dingleberries. We have a long list of people that we've done. We've gotten Courtney Clenny and let's see, Chandler Halderson and a bunch. So if you guys need a little bit of humor after this, then I would definitely recommend you go look at that. And there will be no nightly newsy news tonight because I am going to be saving trying to go to bed early so that I'm willing a good day to come into existence so that I can take them to the apple orchard and let them pick some apples and do some fun things. I'm definitely more willing to use my walker outside. So I want CRPS to stop stealing a lot of these things. So I am hoping that we get to go do that, but I will be resting tonight just to make sure that happens. I will still have mornings with Mo tomorrow and maybe get out some videos on these orders if they come out. But have a wonderful day. Be kind to yourself. Be kind to others. Oh no, we let someone else with legal authority and waivers and such teach the kiddos to drive. I told them that there was no way and not enough chloroform gummies and vodka to make me a mellow person in order to teach my children how to drive. So I let professionals with the real brake on the other side do that. Bye, you guys. Have a great day. Thanks for joining me, and I will be back in the morning. See you guys later. Okay, let's see if this actually works.